Singleton will be attending virtually today. Audience members, I want to start by asking you to please silence your electronic devices. I would also like to remind you that in addition to the audience in this room, we have people watching and listening online, so please consider your language in comments and testimony today. Today's meeting is a hybrid board meeting. Some presenters and guests will appear in person and some will appear virtually. For those presenting virtually, please mute your mic when not speaking, and when presenting, make sure to unmute your mic and turn on your camera. For those joining us in person to present or provide public testimony, please turn your mic on when you begin speaking so the green light is showing, and off when you've completed your remarks so the red light is showing. For all presenters, please state your name for the record before speaking or responding to questions. May I have a motion on the consent calendar? Second. Commissioner Jones-Dickson moves. Commissioner Moyer seconds. Approval of the consent calendar. All those in favor, please say aye. 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 The consent calendar is approved.
Opportunity for public comment on non-agenda matters. This is a time for the board to hear public testimony, not for board deliberation. When it's your turn to speak, I will call your name and unmute you or call you to the presenters table. I will set a timer for 3 minutes when you begin speaking and announce when your time is up, at which point please wrap up your sentence. We have 7 people signed up for verbal testimony and received 8 written testimonies, which were shared with board members and staff. Our first group of 4 up is going to be Injured and Pissed Off, Ann Casper, Mike Lizito, and Lightning.
My name's Injured and Pissed Off, and I spoke here June the 11th, and I have another paper that I had paid my care facility. The human rights, apparently one of the situations is receiving medical attention and things. I still haven't had my cataracts removed. I got cataracts in both eyes besides being legally blind, so I can't see very good at all currently. My blood pressure was 172 and I canceled the eye appointment, and they haven't rescheduled me for another or any other medical appointment since, so apparently it just isn't working too well yet. But I do like the care facility. The $19,166 a month that the state of Oregon is paying, which I explained June the 11th here, and I had a penny in my hand. Well, I didn't bring the penny today, but that penny was more than I've ever been paid by the state, the county, the city, the housing authority. If you heard, the administrators quit or got fired for spending the taxpayers' money in Hawaii, $100,000 for the last 3 years. Having fun, I guess. I hope she was having fun. I have trouble with my memory because of the spinal cord injuries. There was something else I was going to... fair and equal protection under the law. You've heard the old saying, you can't fight City Hall. Well, hell no, it's not just City Hall, it's the state, the federal government. I even put in complaints to the United States Department of Justice because the state of Oregon was allowing my service animal to be attacked, which is against Oregon state law as well as county law. But because the city owned the property, they did nothing. And I'm not satisfied, and of course, I don't feel too well to dispute this on my debit card at $1,375 a month because where they misappropriated and prevaricated, and I've sustained injuries twisting my spine 12.4 degrees, damaging my kidneys. I don't even have enough balance to stand up and walk without holding on to something such as this rollator, which I was explaining to your staff the June 11th that this is a POS. It would be POT if I said piece of turd. Of course, turd's a 4-letter word. Well, there's other words that you can fill in the blanks. They want to charge me. Apparently, they delivered this. Thanks.
So thanks. Injured, if you need to talk with somebody more about that, I've got staff at the back of the room who can help with that. And they can come talk to you. Thank you. Good morning.
Good morning. I'm Ann Casper. I am a student at University of Oregon in virtual reality, augmented reality, and XR. I'm also now in the Oregon Consumer Advisory Council, where we get to advise OHA on behavioral health matters, so hoping to work with you on that. I've just come back from Ottawa, Canada at the Global Leadership Exchange. Very lucky to be able to work with ministers and people around the globe talking about mental health leadership. I also came back from Minnesota, the Self-Direction Conference. We close up our self-direction program here, but so many people across the country are looking into it, and we had a full house at our conference seminar. I also want to talk to you also a little bit about the College of Behavioral Health Leadership. It's really important to look at how do we support our leaders who are doing mental health leadership. This is a very difficult field, and if you know how to reach me, you can reach me and I can talk about that. I want to mention a water desert. As you know, my house hasn't had water for 6 years because of house fire and legal. And 7-Eleven is closed now, Walgreens is closed now, Lloyd Center will be closing up. It's really hard to get water. And also a whole bunch of restaurants. I'm really worried about the economic area in that inner northeast Portland. On August 15th, I'm inviting the 3 chair candidates here to Open Signal to do a town hall. I've been doing TV shows for 20 years on mental health. My TV crew is going to do it for free. I've written to all 3 candidates. One has said they would come. And it's going to be a discussion, not a fight. It's going to talk about, we want to hear your mental health policies, and you will meet the mental health community that you haven't met yet here in this room. And anybody else is welcome to come. I teach preschool Japanese once a week at Wild and Flood of World. We're very excited to become a preschool for all school. And that school, I've been very happy to watch. There's been no labeling of kids. I'm very worried about mental health labeling because I was given one 18. It took my life off a different direction, which it didn't need to. It's caused a lot of harm. I think you can help kids without labels. I've seen it in that preschool. So if you want to talk to me about that, you can. I've watched where the teacher can work with the parents, with the behavioral specialist, and with the kids themselves. I've seen children change from 3-year-old to 6-year-old, 5-year-olds, where they're not going to have problems later on in their life. And again, the method's called Emile Reggio. It's used in the Mount Hood Community College's Early Start programs. But I think there's hope here, and I'm also quite concerned if you start writing notes about kids, what happens to those notes in the future with the health information technology. I'd like to thank you again for your work. It's not an easy time to be in leadership, and I hope you have a great summer. Thank you.
Thank you. Good morning.
Good morning, Chair and Commissioners. My name is Michael Ozito, and I'm an early childhood educator here in Multnomah County. First, I'd like to thank Commissioner Moyer for meeting with me in person, and Commissioner Singleton for arranging a meeting with their Chief of Staff. I genuinely appreciate those conversations and your willingness to listen. I'm here again because I believe in preschool for all, but I believe we've reached a point where listening needs to become action. Over the past several months, my conversations have expanded, not just with educators, but with providers, county staff, elected officials, and state agencies. While I've learned a great deal, the same workforce concerns continue to surface. Educator representation, workforce retention, health insurance, organ registry delays, and accountability. One of the biggest concerns I've continued to raise is educator representation. Earlier this year, Preschool for All convened both a program advisory group and a technical advisory group. Those groups were another opportunity to ensure active frontline preschool teachers had a meaningful role in shaping implementation. Yet neither group included an active frontline preschool teacher. That was another missed opportunity. After following up with Preschool for All leadership, I was told they agree that frontline educator perspectives are crucial and they are continuing to evaluate ways to engage educators in meaningful ways. I appreciate that response. But I'd like to ask something more concrete. What is the timeline for ensuring active frontline preschool teachers have a permanent seat on the table? Another barrier facing educators is the Oregon Registry, a credentialing system that determines many educators' qualifications, hiring eligibility, and often their wage floor. Registry delays don't just delay paperwork, they delay hiring, wages, and careers. I have documentation showing that Preschool for All providers, Preschool Promise, and licensors can request expedited Oregon Registry processing when staffing needs arise. But when educators are unemployed and changing jobs, waiting on a registry step that determines whether they're hired or what they're paid, there is no comparable expedited pathway available to them. An educator can spend more than 45 or even 50 days waiting for job opportunities while they're waiting for their ORO step. We've created a system that can move quickly when providers need staffing, but not when educators need work. I also reached out to the Department of Early Learning and Care to better understand oversight. They explained that licensing enforces licensing rules, while additional workforce expectations tied to Preschool for All are determined by the program itself. That leaves an important question. Who is independently verifying that Preschool for All workforce expectations are actually being met? Finally, I'd like to thank you.
Thank you. Good morning.
Good morning. My name is Lightning. I represent Lightning Superhumanity AI Fun for Everyone Lab. One of the things about Tom Dundon I find so interesting is that I think he's the life of the party. I really do. And I'm going to give him a name called Slam Dunk Tom Dundon. That's my name for Tom Dundon. Now, to Chair Peterson, it's my understanding they're asking you for about $100 million, but you're not going to take any ownership rights in the arena. That would be a foolish move to make. You want ownership rights if you hand over that kind of money. Now, I was the only person that, probably in the United States, that said Tom Dundon made $2 billion right on the buy of Portland Trail Blazers. Because most of the experts like Sportico and the top experts were anywhere from $3 billion, $500 million to $4 billion. Now, here's one suggestion to you, Slam Dunk Dundon. When you're looking at the expansion moves being made right now, especially I'm focusing on Las Vegas, Miriam Alderson, that I know you placed a bid to try to end up with the Portland Trail Blazers. Unfortunately, you probably came in too low. Now, that expansion fee is going to hit anywhere from $7 billion to $10 billion. So I'm asking Tom Dundon, I'm going to recalibrate and said, instead of just making $2 billion, I'm going to make you $6 billion on the buy. If you do a relocation fee right now to Vegas, right now, and get in front of the governors of the NBA and say, I want to go to Vegas. I've always dreamed about that. Correct me, sir, but if you transfer over to Vegas and it's already set at about a $10 billion expansion fee, you just made $6 billion on the buy, Slam Dunk Dundon. $6 billion. You will not sign a 20-year lease. You should already say that up front. You're locked in till 2030. You want to have the ability to relocate. You don't want to pay those fees. You don't want to pay any penalties and fines that these municipalities think they can lock you in and say, hey, anything we put into the property, when you leave, you're going to pay us all back. That's a laughable joke, municipalities. You're not playing with the amateurs here. So anyway, Tom, put your relocation fee into Vegas, sit back, talk to the governors. And to you, Adam Silver, let me say this to NBA Commissioner. I am demanding the governors to raise your yearly salary to $25 million from the $10 million per year. You deserve every penny, but let me say this to you. Do not stop Tom Dundon for going to Vegas and making $6 billion on the buy and proving lightning right. Thank you, sir.
Thank you.
Next, we have Faria Omar, Jalen Patel, Dan Hagan, and Crystal Ann Major.
Good morning.
Good morning.
You can go ahead and begin and just hit the button on the mic down there. There you go.
Okay. It's a pleasure to be in front of you commissioners today. My name is Farhiya Omar. I am a mental health associate. I'm the founder of Rising Tides. And today I have a humble request from the Board of Commissioners to support in the form of funding and resource as well as guidance, an initiative that's meant to close the gap in Recovery Circle. The Recovery Circle being residential care, detox, outpatient, and inpatient. Right now, people are circulating through it without an exit point, and a lot of resource is being put towards it without an exit point. If I could take a step back and sort of expand on where my passion comes from. I am a benefactor, or was a benefactor, of social services. My family and families like my own relied on this at times of transition, right? And so I feel we have a responsibility to it. That coupled with 3 years on the ground working with people that are homeless, trying to move them along the different chain of services, it's become very evident that there isn't really a continuum of care and that there isn't really a structure put in place to make that happen. And it's been quite frustrating for people that are on the ground that are trying to make the changes necessary. Now, Commissioner Edwards and Commissioner Jones, we've kind of exchanged paths in the past where I was made aware that you guys are the public health authority for the county to be leaned on for leaders to lean on when they want to bring initiatives such as this. So since 2023, I've worked with a staff of 25 in an outpatient mental health setting. However, you can't really work on a person's internal governance ability to cope with some of the traumas and pain without giving them the basic needs such as food, shelter, a safe environment to actually change. However, due to there being a lack of integration, continuum of care, we've failed short of that. And in that time, we had to offset about 50 clients and really try to reimagine how we would go about this problem. And so coming here today and giving my first testimony to the Board of Commissioners, I figured I'd bluntly ask for support and guidance on how to close that gap. I think that, there's a lot of heartfelt initiatives, yet we're all just walking and working past each other rather than together. So what I hope to come from this testimony is an exchange of conversation and an actual path forward with the respective commissioners today. Thank you very much.
Thank you. Good morning. And then you just hit the button right there. There you go.
Good morning. Good morning. Good morning, Chair, Commissioners, and county staff. My name is Jalen Patel, and I'm the son of Hina Patel, who is the owner of the Golden Line Motel on East Powell Boulevard in Gresham. So All Motel is a small family-owned and operated motel. And I'm here today because our family is facing an urgent situation, and we're asking the Multnomah County and the board for help finding a solution. Since 2014, our motel has worked very closely with a Multnomah County program called the Choice Model Program, which housed adults with complex behavioral health needs at our property. And for the past 12 years, our motel has primarily operated around this program, including both temporary and longer-term housing. And suddenly, we were recently informed that this program had lost its funding, and it shut down 2 days ago on June 30th at the end of the fiscal year. Over the past few weeks, all the program participants have left, and our motel is now fully vacant. This has created a sudden and serious financial hardship for our family, and because the property has operated around this county program for so many years and provided housing to participants in our entire motel, we cannot simply return to regular motel operations. There are repairs, damages, and operational issues that need to be addressed because of the condition the property was left in. And at the same time, our property is already familiar with the county housing program operations. We have experience serving vulnerable populations and working within a structured housing environment. And that is why we believe Golden Knight Motel could continue serving an important county need through a room block agreement, master lease, lease to purchase option, or purchase discussion. We have been in communication since July 2024 regarding possible multiple opportunities with the Multnomah County Homeless Services Department and the Joint Office of Homeless Services, including a possible room block, lease, or purchase. But now that the Choice program has ended suddenly, the situation has become extremely urgent. And the loss of this program has put my and my sister's college education at risk, so we're serious, flexible, and ready to work with the county or any appropriate partner. So I'm respectfully asking the board to please support us and help move this conversation forward quickly, whether through a room block agreement, master lease, lease to purchase option, or purchase of the property, or any other option that you deem necessary. Thank you.
Thank you. And Jalen, you can talk with Natalie on my staff at the back of the room. She can talk with you and your mom. Thank you.
That's it for public testimony. We can move on to R1.
Okay, thank you, Tasia.
R1, adopting a population emergency release plan for the Department of Community Justice Juvenile Services Division facilities to be implemented in accordance with ORS 419A.055 in the event that the maximum capacity of the juvenile detention facility is exceeded.
May I have a motion?
Second.
Commissioner Jones-Dixon moves, Commissioner Moyer seconds, approval of R1. So the next item is the continuation of the conversation we started last week with DCJ when they presented the juvenile population emergency resolution. They're coming back today with additional details on the operational tiers used to review emergency releases, more information about the daily census, and an overview of victim notification procedure. I want to thank the department for getting these additional details to the board earlier this week, and appreciate the work from Dr. Armstrong Romero and Suzanne. Thank you for joining today. I will turn it over to you.
Great. Good morning, Chair Vega Peterson and Commissioners. I'm Suzanne Brown McBride. I'm Deputy Director at the Department of Community Justice, and I use she, her pronouns. I'm joined today by Dr. Kyla Armstrong Romero, our Juvenile Services Division Director. Thank you for taking time today to continue the discussion on the proposed resolution to adopt a population emergency release plan for the Department of Community Justice Juvenile Services Division. Building on our discussion from last week, we're asking the board to authorize a system designed to manage capacity overages while ensuring statutory compliance and maintaining safe, trauma-informed environments for both the youth that are in our care and the staff that supervise them. Following the June 25th board meeting, DCJ provided the board with additional follow-up materials, including responses provided to Commissioner Brim Edwards, along with detention screening instrument and the average daily population data from 2018 to present. Today, we'll provide more detail on three things: the tiered structure that would be applied in emergency release scenarios, a snapshot census report that we are able to provide that would give a daily sort of update on what our population looks like in detention, and also we'll walk through the victim notification process in the event of an emergency release. And could I go to the next slide, please? And I'll turn it over to Dr. Armstrong Romero.
Good morning.
Good morning, Chair and Commissioners. My name is Dr. Kyla Armstrong Romero, and I am the Juvenile Services Division Director with DCJ. I use she, her pronouns. I will walk us through how this emergency plan operates on a practical, legal, and operational level. The plan defines maximum operational capacity as the maximum number of youth that can be safely housed based on the lower of three things: A, physical bed space; B, budgeted capacity; or C, the number of youth manageable under the staffing ratios mandated by state and federal guidelines and collective bargaining agreement. A population emergency occurs when the number of youth in detention exceeds the maximum operational capacity. By law, DCJ's JSD has statutory intake and supervision authority to transition a lower risk, currently detained youth out of a secure bed, and Oregon Revised Statute provides criteria for emergency release review that foresees 3 tiers. During the June 25th board meeting, we provided several scenarios that utilize this tiered system that I will walk through in more detail. An overview of the tiers is shown on the screen here, and the relevant release authority, governing statute, and statutory criteria. Tier 1 applies to youth who are currently detained on lower-level non-criminal matters, such as technical violations of their supervision or short-term sanctions, such as a probation violation. The releasing authority in these cases may be DCJ's JSD or Oregon Youth Authority. Tier 2 applies to youth facing pre-adjudication charges who are evaluated through validated screening instruments, but may face external placement barriers. Statutory criteria establish that release consideration is strictly governed by the youth score on the detention screening assessment, the DSI, failure to appear FTA records, and individual escape history to ensure public and victim safety. Statute also provides the social preclusion safeguard, where if a screening shows a youth is low risk, but their parent or guardian actively refused to assume custody, or there are 0 available shelter beds, a mandatory 36-hour hold override is triggered, and a release cannot occur if it results in unsafe community conditions or immediate youth homelessness. The releasing authority in these cases is DCJ's JSD. Tier 3 establishes a strict statutory firewall. Youth in this tier cannot be released under any capacity management protocol and can only be released by going directly before a judge. Statutory criteria establishes that capacity management plan strictly prioritizes bed space to retain youth charged with violent felonies or ORS 137.707 offenses. Any charge involving an operable firearm under ORS 166.250 triggers an automatic non-negotiable statutory hold. The releasing authority in these cases is the Oregon Judicial Department presiding court. No emergency release can occur for youth in this tier without a signed judge's order. They must remain securely detained until they go to court. Upon referral to the courts, the district attorney and defense counsel are notified and consulted. In the event that maximum operational capacity has been reached and there are no youth that meet Tier 1 or Tier 2 criteria, DCJ would petition the court for emergency hearings to make release decisions. If the court denies any of the Tier 3 and we are still at capacity, there are 11 other juvenile detention facilities across the state of Oregon that we have agreements with that we could also petition to move youth if we had to. Next slide, please. On this slide, you can see our aggregated daily census report that DCJ can provide to board members and criminal justice partners on a daily basis through the Oregon Youth Authority Case Management Juvenile Justice Information System. This includes occupancy details broken down by pod layout and utilization and by gender identity. I will now hand it over to Suzanne Brown McBride to cover victim notifications in the event of an emergency release. However, I do want to note that the Juvenile Deputy District Attorney, Eric Zimmerman, is in the room, and we also have our Detention Senior Manager, James Hartman, in the room as well if there are questions from the board. Suzanne?
Sure. Next slide, please. Oregon's Constitution codifies rights for victims, including the right to be informed of their rights, as well as to receive notifications at critical stages of the justice process. This is pre- and post-adjudication. DCJ is responsible for notification, post-adjudication, as well as responsible for conducting notifications related to changes in custody status connected to detention. For victims, and along with, we also additionally provide advocacy for all victims who've been harmed by somebody on supervision with DCJ. This is outlined in an intergovernmental agency agreement between the District Attorney's Office and DCJ. But for sort of purposes of this conversation, it's important to note that generally the District Attorney is responsible for all victim services pre-adjudication, and DCJ is responsible for victim services post-adjudication. And what we're going to walk through is sort of the places where our two offices work together hand in hand frequently and constantly, and actually share a data source that describes sort of who victims are and how to be able to contact them. As cases move through the criminal justice system, victim and survivor services do as well. And the District Attorney Victim Services Team works closely with DCJ's Victim Services Team to facilitate a smooth handoff that eases the process for the victims as they work through that process. This was significantly improved by the launch of the county's Case Companion portal last year that helps victims of crime request and understand their rights. And we did do a briefing with you about that a few months ago. The first one is, step one, is that victims opt in to receive notification in Case Companion. And so they have the option to sort of say, these are the notifications that are available to you, and then victims can choose what, if any, notifications that they want to have. And that information is automatically carried forward from the DA to DCJ. This is a shared platform that information goes back and forth. When a victim is opted in, they receive notifications at several key stages, including at release and critical stage court hearings. In line with this, DCJ's Victim and Survivor Services has a policy and process that facilitates victim notification, including for all releases from our juvenile detention facility where a victim is named. And so this doesn't just pertain to emergency releases, this would pertain for any change in custody status coming out of our detention facility. This process is the same whether the youth is released based on a court order or due to capacity management. You'll see in the overview of the process on the slide here that I'll briefly walk through. First, when a victim chooses to opt in for notifications, this information is noted in the Juvenile Justice Information System, or JJIS, that Kyla referenced earlier. If a release from detention is initiated, JJIS pre-populates a release form with victim notification details and prompts a notification to be completed prior to the release. Notification is done by telephone, most frequently by DCJ advocacy staff. At this stage, the victim is referred to additional advocacy in line with the intergovernmental agreement previously identified. If the youth that is being released from custody is pre-adjudication, additional victim advocacy would be referred to the District Attorney Victim Advocates for support and services, which could include safety planning if appropriate. If the youth has been adjudicated, additional victim advocacy can be provided by DCJ Victim Advocates that include safety planning and support with our Limited Victims Emergency Assistance Fund. All victims also have the right to be notified about critical stage hearings during the adjudication and supervision of individuals who cause them harm. In the context of emergency release, for Tier 3 youth, any judicial review related to release is considered a critical stage hearing, and victims who've chosen to opt in for notification would receive notification about that event as well, with advocacy following that same path as described above. So for named victims who are connected to a Tier 3 youth, they could receive 2 notifications about developments related to any potential emergency release. And at both notifications, they would be referred to advocacy services. Again, this process applies to all releases from detention, whether or not we have initiated emergency management releases, the process would be the same. I'd like to underline that both the District Attorney's Office and DCJ are deeply committed to providing these services and are constitutionally required to provide notifications. Advocacy, however, is not constitutionally required, and our resources to provide these in-depth and often complex services is becoming increasingly stressed. For example, in the last fiscal year, DCJ had to eliminate one of our victim advocate positions in order to meet fiscal constraints. So we continue to be committed to making sure that these notifications happen and to trying to make sure that the advocacy and the safety planning and all the resources for victims are present, but this continues to put us on, this is continually under budget pressure. Next slide, please. We're happy to answer any questions that you have.
Thank you both so much for being here and providing this additional information. Tasha, did we have any public testimony on this item?
Yes, we have one person signed up.
Okay, so if you wouldn't mind taking a seat, and then we'll bring you back up for any questions.
Lightning.
Yes, my name is Lightning. I represent Lightning Superhumanity. Again, pertaining to the juveniles themselves that are currently in the Donald E. Long Juvenile Detention Center. As I stated before, I wanted to have a clear understanding on the complaint process. If there's any issues within from the juveniles toward any staff or anyone else in there, how does the complaint process operate? Who looks over the complaints? Who makes the final decisions about the complaints? And it's my understanding the complaints are a, quote, public record, cannot be damaged, altered, or thrown away in any form. Now, one of the things through my studies is that they have what's called the Child Protection Ombudsman. Now, you have an ombudsman here, but do they focus on the child protection issue? Now, they do that in Colorado, and why I'm asking that to be in place here is that juveniles, if they have a problem within, let's say if it's a restraint, if it's physical force, whatever the problem may be, even sexual abuse, as you all know at McLaren what happened. There's 10 criminal indictments against staff at McLaren. And knowing that, we have to have an independent body with oversight. You have to have that. And by putting them in position, that allows the juvenile within to actually place a phone call out to them directly and to have communication directly so they can file their complaint with the ombudsman. And the county has one, but why are they not taking it to the juvenile detention center? When we know what happened in McLaren, you can just pull that up and go over that and it will shock you, literally shock you on what some of the allegations and the indictments against staff that have been proven and were made. Shock you. So why are you not providing that mechanism for the juveniles within to make contact to an independent body to review and move forward? I'll tell you why you do that, Multnomah County, and I'm going to point at the county attorney. Because you try to prevent lawsuits. You try to save the county money, but you put the juveniles' safety in jeopardy by doing that. And if you would like to, anybody, you can go down a list of lawsuits from SOCO Love, S-O-K-O Love Law, on these juvenile detention centers on billions and billions and billions of lawsuits filed and won. What happens at these centers?
Thank you.
And I'm asking the county attorney to quit covering up for you and take care of the children.
All right, Kyla and Suzanne, I'm going to invite you to come back up.
Keep your attack dog over there. Thank you. Well, don't stand up and act like an attack dog.
Lightning.
Hey, I made my point.
There's no,
That's the end of discussion.
somebody's just doing their dog. There's no need for name calling. That is not respectful.
Well, when they're standing up getting ready to make their move on me, that's an attack dog, okay? It is what it is.
All right. Sorry about that. All right, we will go back. We'll go to the board for questions. We'll start with Commissioner Broome-Edwards.
Good morning. First of all, I want to thank you for, before last week's meeting, providing some very detailed answers to questions I had, and then the subsequent discussions we had last week and the work you all did to take what we discussed, which was more of the details around the plan, and put it into an addendum. So I want to thank you for that, and I had some follow-up questions, and I have a potential amendment. And I think when we had this discussion last week, when it was raised, it was because of the requirement that the court is not doing this anymore, but now it's the county commission approving the plan. As I said last week, I feel like it's more than just picking this up and shifting it to a different body, because we as a commission, if it's our plan, that we have a responsibility to know what's in it, to ensure that the provisions that are and elements that are important to have in the plan and be sort of daylighted and transparent, that we have that in there. So I'm really appreciative that that's been highlighted now in the operational plan, so we can actually see how it works with more detail. And again, it's not that it didn't exist, I want to be clear, it just wasn't in our plan, and if we're going to be accountable for it, to know what that means. So I had some just follow-up questions. I appreciate that. So in the addendum, it has these new 3 tiers, and you discuss them. I'm trying to understand more the relationship between tier 2 and tier 3. And the reason I ask this is, as we discussed last week, many of the youth that are in the county's custody are for much more serious alleged crimes than in the past. And so between tier 2 and tier 3, tier 3 is that they could only be released by going before a judge with a signed order, but 2, it appears that that's not the case. And share like what the interpretation of risk is, or high risk, between those two tiers. And I don't know if it's that there is a particular score on the detention screening instrument or some other way that you get sorted, because it seems like approval of this plan, tier 1 and tier 2, it's an internal process, whereas tier 3, it would require this sort of extra step with the judge's order saying that somebody could be released. So can you just share the difference between that in terms of risk between 2 and 3?
Absolutely, and thank you for the question. Again, for the record, my name is Dr. Kyla Armstrong Romero, and I think about it in the terms of the adult system versus the juvenile system. So if you think about the adult system, adults may be eligible for bail. Kids are not eligible for bail. And so the way that I look at tier 2 is that, for example, if there's a charge, and what's different about tier 2 and tier 3 is that there are certain charges per statute that require us to go before the court, that we could not make the decision on our own. And I would defer to I would phone a friend to DDA Zimmerman to discuss the charges for tier 3 that would require us to petition the court. Tier 2, that would be an example I can give, is maybe a burglary or maybe a theft or stolen vehicle, perhaps, depending on, it's hard to like think off of the cuff what kind of cases, but they would be non-serious violent offenses. And DDA Zimmerman, if you would like, maybe can shed more light on those types of cases. But the way that I see tier 2 is, and we do this every day when considering youth to be released from detention, it's that we have this evaluation. We do utilize the screening instrument to assess risk. And thank you so much for bringing up the point about risk. I think that in the case of kids, there are various factors that impact their risk that can make them more high risk, that are outside of their control. So for example, their living situation can make a youth high risk. And so when we discuss the risk piece, it's typically we're looking at the charges that they are accused of. Does that help?
Yes. Thank you for sharing that. So another question I have, and this is maybe it's a question for the chair. I just want to make sure that what the commission would be adopting is the resolution, which is the capacity management plan and the addendum.
I'm going to have Jenny Madcor answer that.
Yeah, so what was noticed here was the resolution and the capacity management plan. So if the board wants to adopt the addendum, we need a motion to amend to add the addendum.
So the addendum wouldn't naturally be part of what we're,
No, we don't, our rules don't allow us to add to the noticed item without a formal amendment. So we have the addendum that's been noticed online, and so if the board wanted to actually have that be an adopted board document, we need a motion to include it. Further, if there were any proposed amendments to the addendum, then those things could just be talked about and decided first before a formal motion is made.
okay, so the motion would, so if no amendments are made, it means that we'd be adopting the resolution and the capacity management plan, but not the addendum.
That's correct. And the addendum, which has been noticed online, would be for informational purposes, considered board presentation materials and additional context and legislative history.
Okay, so I'll be offering an amendment to do that, just, again, because of the shift to the accountability to the commission, that'd be something I want to offer. But I'll go forward with my other questions. Just for the record, can you clarify one more time if a youth is, I mean, this is an issue I brought up last week about if you get down to, say, for example, you've released everyone in Tier 1 and Tier 2 that could be released. You get to Tier 3, and the judge says, you go before a judge, which is the process, and they decline to release. The mechanism then is you look at somewhere else in the state. Is that for placement?
That would be an option.
Are there other options? Just curious.
If the court says no, that they must be held in secure detention, and we have absolutely no other types of releases available to us, then we would be required by law to hold them. And if we didn't have either the staffing or the building to do that, then we would look to one of our other facilities. For example, we would look to Marion County or Yamhill County or Norcor as examples.
Okay. Thank you for getting the data that I asked for, this like pre-pandemic, just to see the trends, because if my interpretation of the trends of the daily census, and then also how long people are staying. So if I were to summarize it, is like the trend is there's fewer, but staying for longer periods of time.
That's correct.
Yeah. So I just, for the larger commission, think that's a larger discussion for all of us with our partners at DCJ and the DA's office, because in some ways we're being backed into this because of a different set of circumstances. It's not that we actually have more youth that are being held, it's the length of the time. So hopefully we'll have that discussion. I also appreciate the operational plan that it has, that DCJ will be providing notice to the commission if the emergency release mechanism is going to be used. I mean, we talked about last time, the Sheriff for Adults has a system where we get a daily census and see where we are. How often do you think we would either be getting you've also committed to providing regular information about the daily census. On what cadence do you think that information on the daily census would be provided? And then what would it look like for, if you were going to put the plan into action to actually have an emergency release, what would that look like?
So I will say that we can absolutely have a census. The slideshow that we shared, that census could be automatically sent to the board starting today if you'd like. And that's no problem. I think the unique piece of this situation is that we haven't had to operationalize the emergency release plan. It was that we were close to it, and thankfully to DDA Zimmerman mentioned that we worked very closely together when we were at that point where we were discussing what it could look like. I think the important piece that I hope to elevate is that the DA's office has worked very, very hard, especially on the juvenile side under DDA Zimmerman's leadership, to resolve the backlog that I think where we saw an influx of youth. And I don't know if we will be back in that situation, but if we were to, let's say, be at 30 youth or 29 youth, then we would be noticing the board, and then we would notice that we are at our Multnomah County capacity and that we plan to execute, let's say, X number of releases, and so by the next day, then you would have the census. And so I'm guessing, because we haven't had to do this before, but if DDA Zimmerman would like to add any additional details.
And not for this morning or contingent upon the vote. I'd love to have just a little more thought of what that might look like. We know, at least from the sheriff's office, that often it's like after a 3-day weekend, or when there's like one large event, then you get that. And so the reason I'm asking is, like, I wouldn't want it to be a trailing event. I mean, to be like the notification, like, hey, this is already, it's happened. So just getting a sense of like how you all are thinking about that might happen. And just given the change in accountability to the commission, I'd be interested in that. And then let's see. I think that is all my questions. And I think, Chair, I maybe wait for everybody else to ask their questions and then offer my amendments.
Sure, we can do that.
Okay.
Great. Commissioner Jones-Dixon, any questions or?
Yeah, just one question. And first, thank you for bringing forward the resolution, as I mentioned last week. Have a question for DA Zimmerman. Are you supportive, or you can just say yes or no from where you are, unless you have anything to add, supportive of the resolution as it's written? Do you have any concerns? I know you guys have been working closely up to this point.
I wasn't sent the resolution. I haven't seen it. The one that was on the board earlier.
I think it's the plan in general.
The plan in general. Yeah. I'm sorry. Thank you, Chair.
The plan in general, I mean, I agree with the tiered system, and that would make sense. I don't think we have anyone in Tier 1 hardly ever, very rarely in custody, but that part definitely makes sense. I do like the collaboration between my office and Department of Community Justice. I think it's important from a victim standpoint and from a community safety standpoint. I think our office is very in tune with what's going on in the streets. We talk to police agencies on a regular basis, and I think it's important to have that input when you're making decisions of people that could be like situated in the same tier. So I really do think that collaboration is important when making these decisions.
Got it. Great. I don't have any further questions. I do want to make I want to thank Lightning for bringing up the concerns around the system at large. I have no concerns regarding our juvenile system. I've visited multiple times. I trust Dr. Armstrong and Romero, DA Zimmerman, and Director Pena. We have a full grievance process as well. OIA, that's a completely separate, different system that the state's working on. So thank you for highlighting that. Personally, tracking that myself. So just want to say that, and I'm fully supportive of the case, the plan that you've brought forward. Thank you for your work on this.
Thank you, Commissioner. Commissioner Moyer.
Yeah, over the weekend I was at the Oregon Association of Counties Legislative Retreat. In the topic of juvenile justice came up, and it was brought up by some other counties that they were having some issues with DHS and children who are in the custody of the state, which means child welfare, and having individuals who did not need to be in custody and yet unable to get DHS to find an appropriate placement. Is that something that we are experiencing?
We have a very strong relationship with the branch here, and we have staffings with DHS regularly. I would say that where it comes down to where we need more collaboration is just when we get close to having a kid who can be released, and the question is who takes custody? Is it OYA or is it DHS? And there's been some cases where it may have been more appropriate for DHS to take custody versus OYA in order to try to divert them from the criminal justice system. And we've found that DHS kind of proactively, they don't really have a lot of options, especially for adolescents, and those options have become less and less. And so that's been the primary issue. But as it relates to kids who, let's say, for example, are in that tier 2 and they don't have anywhere to go, if there were options like our assessment and evaluation program or other temporary housing, that would be a benefit. But I understand there's the fiscal constraint for the state as well for DHS. So it's working through some of those pieces that are unique, but the types of kids that we have in detention, we get who we get in the door, and it's not very common that they only have a DHS case. They typically also have delinquency.
Okay, thank you. It may be a totally impossible thing to answer, since we seem to be going in a direction that maybe changes, maybe doesn't. Based on post-COVID and the pace of this trend, how often are we concerned that this would have to be used?
I would say personally, I appreciate the question, and I moved to Multnomah County because of the reforms and the leadership of kind of where we were as leaders across the country with juvenile justice and the reforms with juvenile detention alternative initiatives. We work very, very hard to not keep kids in detention. And I think that we have the best detention center across the state in terms of like restorative justice and the programming that we provide for kids who are in detention. And so with our focus of getting kids out who are appropriate to be out, I would say that it's extremely rare that we would be in this circumstance. I think with the backlog from the DA's office, we weren't quite aware of the significance of that and how that impacted our population. And I think that, the collaboration with partners, so for example, if there's more district attorneys, if there's more law enforcement, that also means that there's perhaps more referrals to juvenile detention. And when we make increases to one system, kind of looking at the others and seeing the cascading effect of that. So I would say that we try really hard not to have kids there who are there, and I don't have a crystal ball, and hopefully we will not be in a situation where we would be over or at capacity.
Okay, thank you.
Thank you.
Thank you. Commissioner Singleton.
Thank you, Chair. Doctor, I just want to appreciate all of the work that you've done and for this presentation, as well as your responsiveness to questions, and thanks for sending out that follow-up material. I don't have any questions for the department. Mr. Zimmerman, I'm curious from you how the DA's office is currently notified, since that notification piece and partnership seems to keep coming up. I'm just not clear on what the process currently is.
So the JCCs that are responsible for making that decision or trying to figure out which people should be released, or when we get close to capacity, they would come to my office and we would discuss who's in, who has otherwise OYA holds. A lot of times these youth, they'll be paroled from OYA, but they'll still be pending new county cases, so they'll be held in local custody. And we worked to try and get the ones with OYA supervision as well as DCJ supervision transferred down to McLaren pending their matters to make, I guess, more room. And we did that on numerous occasions. And the backlog, while it was a lot of cases, those type of cases aren't necessarily the cases where kids or youth are being brought into custody and being held on. I mean, they're repeated car theft. They're not the violent crimes. Typically, those rise to the top of the pile when you're reviewing cases on the daily basis. But with respect to that's how we've worked. And I was really appreciative, and in March when we did have those near capacity issues, that I did have the collaboration with the department, and it was I felt like a teamwork and good agency partnership.
Thank you so much. And while I have you, I just want to appreciate your attention to getting more referrals into restorative justice. It's made a big difference, and I hope that that work will continue. I don't have any more questions, Chair, at this time.
Thank you, Commissioner Singleton. I don't have any questions either. I just want to appreciate the additional information and the responsiveness that you all have shown. And thank you, DA, for being here and for continuing to provide, the perspective of the District Attorney's Office on here as we're talking about this issue. Thank you. All right. Now, I believe you have a proposed amendment.
Yes, I have two, and the first one, this is the second one. But the first one would be, and this is reflective of my initial question about whether the addendum was part of it, since the plan is so high level, is that in the resolution, in the resolve section, number 3, after the words, the attached capacity management plan, strike the word is, and add in the words, and addendum R.
So can you say that again? I'm not.
Okay, number 3, after the words, the attached capacity management plan, strike the word is, because it's a singular, and in its place put, and addendum R. So the sentence would read, the attached capacity management plan and addendum R adopted.
Okay. So we have a motion on the table. Do we have a second? Second. Okay, Commissioner Brim Edwards moves, Commissioner Moyer seconds. Now we are under discussion for the amendment as described. Any discussion or questions about that? I have a question, and this is for the department. So I appreciate the additional addendum as part of the board materials for today. Is there any, if we will be adopting the addendum as well as the resolution and the plan, is there any, does that make any difference for you in terms of your ability to update or change the addendum, or is this, would the addendum and the details that are in the addendum only change if we were changing the overall plan?
I think the only caveat would be the 24 hours. So for example, if a youth has to be released on the weekend or after hours, and not to say that we've been in that situation, but having to coordinate with the DA's office, and if we're over capacity, then.
So Dr. Armstrong-Romero, I don't think we're on that addendum. We're not on that amendment.
Oh,
yes.
sorry.
Yeah. No, that's okay. We'll get to that when that one comes up. This is so the motion that's on the table right now is to include the addendum as part of what we as a board would be adopting today. And I just was meant from a kind of an operational standpoint, does that create any additional difficulties or barriers for the way that you need to manage the system?
At first glance, I don't think so.
Okay.
I think that we would have to come to the board if there was some sort of deviation that was, or that we learned about some sort of operational procedure. I mean, we do have operating policies that underlie all of this, and so I think we should be able to do that, but we will come back if that looks like that's not true.
Okay, great, thank you. That's what I wanted to know. Anything from the legal perspective?
Well, from the legal perspective, this addendum would be adopted by the board. So if the department did want to take actions and I haven't thoroughly reviewed this particular addendum, but additional board approval would be required.
Yeah, and that's kind of what I was wondering about it. Okay, great. That was my only question. Any other questions on this part? Okay. Tasia, can we have a roll call vote on this amendment to include the addendum as described?
Commissioner Moyer?
Aye.
Commissioner Singleton?
Yes.
Commissioner Brim-Edwards?
Yes.
Commissioner Jones-Dixon?
Yes.
Chair Vega-Peterson?
Yes, the amendment passes. All right, so now we are back to discussion under the underlying, okay, so now we are back under a discussion for the underlying resolution as amended. Can you, yeah, okay.
So I passed out a second amendment, and this is it's an amendment to the addendum, section 3, under the victim notification requirements. And it's a portion of the amendment that I circulated last week, and it's just the victims' notification requirements. And it's, as we saw in today's, should I get at the table first? So, and then I can explain it. So I'm moving the amendment.
Okay, yes. Okay, so all right, second. So we have Commissioner Brim-Edwards is moving an amendment, Commissioner Jones-Dixon second. So we're now under discussion of the amendment. Would you mind reading it into the record? I know we have the written version.
Okay, so again, it's an amendment to section 3, victim notification requirements. Input and consultation with the District Attorney's Office Juvenile Unit will be provided regarding victim and community safety risks and statutory requirements under ORS 419C.145. The JSD director or their designee shall notify the District Attorney's Office no less than 24 hours prior to a forced release of a youth to ensure compliance with the Oregon Constitution, Article 1, Section 4243, requiring that victims are notified of a youth's forced release. That's the amendment.
And just to clarify, Commissioner, this is an amendment to Section 3 of the addendum.
Yes, that's correct. Not the resolution. Can I speak to the rationale?
Yes.
So as was explained as part of the presentation, depending on whether it's pre-adjudication or post-adjudication, there are different responsibilities in terms of victims notification, with DCJ having some of them and the DA's office having other ones. And this, because most of the process is, majority of it is being run by DCJ, they're going to know if something's happening that would impact their need to notify victims. And this is building in times that the DA's office would, if it was their responsibility, that they would have adequate notice and time to comply with and do what they're statutorily required to do. So it's just building that piece in. And again, there's no reason to do it for DCJ because you all are running the process, and you will know if someone who you have a responsibility to provide, if they have a responsibility to provide victims notification, that they'll automatically know because they're running the process, but the DA may or may not. And Deputy DA Zimmerman, do you want to share your thoughts on it?
On the proposed amendment,
Thank you.
Sorry. Thank you, Kyla. On the proposed amendment, I do think that it's necessary to have that notice. Dr. Armstrong and I were just discussing that the 24 hours in some cases would be difficult depending on, but again, we've known in advance, we can kind of forecast whether the weekend's coming and that we're one from capacity, then we make that decision on a Friday, which gives us plenty of time, and then if it does happen and we have to release someone, we already have that decision made, or at least that's how we did it the last couple times we were close. It's never actually come to the timing, but the 24 hours is just to give our office an opportunity to reach out to the victim and let them know that this is coming, and let them do safety planning and other planning that they need to do and be aware of. So I think it's important to have that built in for those reasons. And I also think it's important to have the consultation again with my office, just knowing the risks that, community safety risks that sometimes the juvenile department might not be as aware of as my office is.
Can I clarify, please?
Yeah.
And I apologize if this was unclear before. So there are two primary things that Victim Services does. They do notification and they do advocacy. In terms of releases from detention, DCJ does all of the notifications, pre-adjudication, post-adjudication, because we're the ones that are connected most to that information. That's why we share a data system with the district attorney's office to do that. What gets referred to the district attorney's office is if there's follow-up advocacy that's required as the result of that notification. So no matter who's coming out, no matter their status of pre or post adjudication, DCJ is the one that is doing that notice for changes in custody status. And then we're collaborating with our district attorney's colleagues on the advocacy side if there's follow-up because they want to do a safety plan or they want to do other pieces. And so I think my only comment on the amendment is we're happy to continue to deeply collaborate like we do right now, but I wanted to make sure that there's not a confusion about whose responsibility it is to do that notice coming out of the institution. I think it would potentially create a lot of confusion and maybe even delays, whereas we would be handling, right now we handle both sides of that.
If it's a pre-adjudication issue, it's the DA's office's responsibility, and that's going to happen in court 100% of the time. But for under this circumstance, if we had a emergency population release. So my office we talk to the victims before the hearing, after the hearing, some that don't want to participate in the hearings, we call them and let them know what happened at the hearing, most of them. So I mean, we're pretty involved with the victims in this case on all pre-adjudication, and I guess that out of the 23 that are in there now, 24 of them are pre-adjudication.
I mean, I think this just demonstrates sort of the complexity, the status of these kids that are in there. The way that we handle this is that it's true that the district attorney's office is working with folks sort of in other stages, like other critical stage hearings and all of that. But when it comes to detention, that's the place where we have centralized those responsibilities for all of the kids that are coming through. So that at that moment, we are able to make those notifications and have a protocol for doing that and have that set out. And so currently right now, like I would argue that that's the most efficient way to do this is that, because this is the policy for any release from custody out of detention, whether that's an emergency release, whether that's a standard release. Right now what's happening is that DCJ does the notice of release from custody. Other notices would be done by other parts of the system because of that pre or post adjudication status. But on the narrow issue of release from custody, that's where DCJ's victim advocates step in and do that work. Because again, they're most connected to sort of that moment to moment decision making.
So I'm not sure what this amendment does then that's different than what is already in the proposed capacity management plan and the standards and the procedures that you're already doing. I mean, I understand that the 24-hour notice is a change, right? But otherwise, I don't understand what this amendment does that's different than the notification that you're already required to do by statute.
If I may, one of the complexities, for example, with Tier 1, we actually have 4 out of 22 kids who are in detention right now on violations. And so let's say, for example, with a couple of them, they may be on a court-ordered 1 to 8 day sanction. And if we had to move them out and we're waiting to coordinate or consult with the DA's office, I think that may there in turn have some impact, and let's say an impact on staffing that we may not be able to, that we would have to plan for, and that would likely be a budget request from our department, and adding like the consultation and the 24 hours, because that would have an impact on our staffing overall.
So it sounds like this isn't, I'm prepared to make a vote or move forward. It sounds like this isn't going to help make things more complicated. Is that correct?
I would say that in the issue of custody release, that we have, I think, a pretty good system in partnership with the DAs. They have the ability to see, in our victim services system that for victims that have asked to be notified, that they're being notified, and that we've consolidated that sort of under DCJ's piece. I think my concern is that this might split those duties in a way that becomes a little more confusing and fractured. And so in this instance, I guess I would argue keeping the status quo in order to make sure that we are just sort of efficiently managing those notifications as any kid is really coming out of custody, not just emergency releases.
Understood. Thank you.
Any more? Yeah, Commissioner Moyer.
How, in those circumstances where you have a violation and we would be in this scenario, how would we know if a victim might need a safety plan? How would you know that a victim might need a safety plan?
So we would look into the record and see that there is a named victim, and if that named victim had indicated that they wanted to be notified, like that their concern was that they wanted to know if somebody had custody. There's like 9 different places where people can choose to have notifications. When we called them and notified them and said this is happening, we would also say, do you want to have advocacy? If this was a pre-adjudication, in the scenario you're proposing, this is a post-adjudication kid. And so they would be speaking to our victim advocates at DCJ, and we would say, we've got advocate resources for you, and we would walk through safety planning and all of that. So that would be that's part of the triage at the point of notification, is to hear, do you have safety concerns? Are there things that we can help you with or refer you to? If this was a kid that was pre-adjudication, we would have that same talk. Are you concerned? Do you feel unsafe? Are there things you need? And then say, let's help get you connected to the district attorney's office and the advocates there, because they're the ones that provide advocacy for pre-adjudication.
Got it. Okay. Thank you.
Commissioner Singleton.
Thank you, Chair. I just had a question, I think maybe back to Mr. Zimmerman. Earlier you said that the process currently works well and that the 24-hour might be difficult in some circumstances, but then it seemed like you said the 24-hour would be helpful. And those are in conflict, because if we pass this, it would require that 24-hour notice. And so I'm just trying to understand, is there a problem with the process as it currently runs? Or what is the need around notice? And is that need then bigger than just this emergency release? Is there something different that the DA's office seems to need around notification from county departments or the sheriff?
Can you put the microphone on? Thank you.
Short answer is no, you don't need that. I do think that ideally you'd have 24 hours, but I think realistically I can see situations where that would be difficult. Bottom line is we'd like to be consulted before any release decisions are made, regardless of the tier or the youth, because there are things going on that we know that the department, I think, would appreciate our collaboration on.
Thank you.
And I don't know that the way that this is currently written effectuates that. So I think more the consultation, it says per the statute doesn't require consultation with the DA's office, the 419C145. So it would be an additional amendment that they consult before release decisions are made.
Thank you. So, Dr. Romero, is there a place that this is codified in DCJ's process or policies, or is there a way to get at the consultation being requested that doesn't require that 24-hour notice?
I think what DDA Zimmerman just mentioned, that we are not required by statute to consult with the DA's office. However, in practice, we have done it in the past. I think one thing that I want to uplift again is that, especially for kids who are pre-adjudicated, I also look at the overall charges and dismissals, and some of the kids who are pre-adjudicated, their case may be dismissed ultimately. And consulting with the DA's office, my concern may be the due process. I think that the court has, when we've needed to have the court weigh in, we have the court weigh in, and we petition the court, and kids who are released from detention, they have a court hearing subsequently. And I think the consultation for kids, I would just need more detail about what consultation exactly means.
Thank you. Oh, go ahead.
I mean, consultation in this respect would be, hey, we're getting close to release, this is our list, who is most appropriate to release. We're thinking these people, oh, I don't think so, this person's brother was just murdered, he should probably stay in custody. Let's release this kid instead for safety purposes.
Thank you. I appreciate those responses and the conversation, and I will be a no on this amendment.
Okay, thank you. Any other discussion on the amendment?
Yeah, just a follow-up. I think what I heard you just say was that you may not want to consult with the DA? Now I'm confused, because it seemed like we don't need to do this because we already do it, but then it was like, well, there may be instances where we don't want to consult with the DA. I was about ready to say, like, I could, based on some assurances, could withdraw the amendment, because it sounded like you said we already do that. But then I think the last statement you said is there may be instances where we don't want to consult with the DA, or it may not be necessary, or in our view, we want to just go to the judge. I'm sorry, can you clarify?
I can absolutely clarify, and it's not that we don't want to consult with the DA. I think I have questions about what consultation means. Is that approval or not? It's unclear the way it's written, and so my inference is that for Tier 3, for example, we consult with the DA's office, with defense. We have conversations, that's written in our policy. We're required to do that. For probation violations, having a consultation with the DA's office, let's say, for example, because this is all encompassing, it's my understanding that it includes Tier 1, 2, and 3. So, for example, you have a court-ordered sanction, a kid may be released within 1 to 8 days. Consulting with the DA's office, when we already have the ability to release, especially releasing on a technical violation, I think that's where I'm confused as to where it comes into play. Tier 3 is pretty clear. That is the consultation, because those are serious instances. I would say that.
What about Tier 2?
Tier 2.
Because I think you have a good point on the Tier 1.
Tier 2, they're going to court, and we do notify. We make notifications to the DA's office. Notification versus consultation, again, that's where I'm a little bit stuck on notification versus consultation. They are notified, consulting with them beforehand, and there's a court hearing that's pending. I think I'm confused.
And I guess I'll just say, just to clarify, consult means consult. It does not mean approval. If I'd meant approval, that's the word I would use. So consult, just like get their input. So Tier 3, yes. Tier 2, you don't think it's necessary because they're notified, and so actually if they have a point of view, they could offer it? I mean, right?
Can I give an example? DDA Zimmerman mentioned a case where a kid may not need to go home to a family member because they know something that we don't know. Tier 2 are the kids that I believe we talked about before, the kids who may not need to be in detention. The consultation with the DA's office to say, no, we don't believe that they should go home because brother may be involved in X, Y, and Z. I think that kids of color, again, the disproportionality and the assumptions sometimes that are made, that is the question. What would that process look like? And again, Tier 2, that's a budgetary note for us as well, having to wait for the district attorney's office to consult with them.
Actually, I was trying to get to yes on your point of view, which was because I agree on Tier 1, not necessary. Tier 3, you're saying it already happens, so it's really Tier 2. But you're saying they're notified? And I think the DA's office, I would just say, they can offer it's offering their point of view, so if they're notified, they can do that, so you may not need this. So I do want to, so you've addressed the issue I have with the first part. The second part, I'm a little bit, I'm somewhat concerned that of the statement that there wouldn't be 24-hour notice to the DA, because that also implies, like, because we don't have time, that like it would be a trailing notice also to the commission. So I guess, I'm trying to think of, I'm looking at the adult system, and I know they have a lot more flexibility, but it's like they see it coming, they're making plans, it's not a surprise. And so I guess I'm just curious, and again, it's more than the DA's office, but you know, the whole system of like that we would have emergency releases with very little notice, because then it implies like strategically we haven't been looking out of like, hey, this is coming, we need to do these things. So ensure me that we wouldn't just be.
Yeah, I'm just, you know, like, with a total capacity of like 29, what if 4 kids got picked up on a really serious charge at 11 p.m.? I mean, I could actually see how that could happen. I mean, when you have over 1,000 beds, that's a projection issue, and you've got 29. I think it's like one real bad incident could be totally not foreseen and happen. So I get it, but I also am like, they're not really the same situation.
I think we're trying to do both and. I mean, we're absolutely committed to trying to, like, if we see something ramping up and we can work with everyone to start, like, figure out how to communicate, if it looks like there's some sort of statistical ramp up, if there's some sort of thing like that, then that becomes the issue. If there's like a surge of kids that get picked up on some sort of arrest, or if we get kids that that we're required to hold because of other reasons, then I think then it may be a trailing indicator. That's sort of the reality of what we're dealing with. It's sort of both and.
Okay, great. So is there any other discussion? Because otherwise we can move to a vote on the amendment.
Well, I was trying to get to, is it needed because of the assurances, and so if it's a Tier 3 and you're going before, you've got to go before a judge, there likely is going to be within a 24-hour window?
The way that I interpret this is that the notification is for the victims, and we actually called the victims immediately. So I don't know if the notification is for the DDA's office to be aware, or if it's for the victims to be aware, or is it for the, I guess that's.
So the DA.
You have a constitutional obligation to notify the victims, and I intend on following that.
Yes, and we do that.
Okay,
So you're saying that happens within
Correct.
more than 24 hours,
It happens immediately.
but it could be less than 24 hours?
Yeah,
Correct.
yes.
Okay.
So are we ready to vote? Or Commissioner, are you going to withdraw the amendment?
I guess, I just want to make sure that I clearly understand what you're saying. So you're saying that there may be cases that the victim gets notified, let's put aside the DA for a moment, the victim gets notified with less than 24 hours.
That could occur, just like it does in the adult system. You know, I mean, I think when you're looking at detention and jail releases, a lot of these are very quick turn. And so, you know, part of the reason why having DCJ do the notification is more efficient is that we're frankly closer to the metal. Like, you know, as soon as a decision is made, we know that we can get that notification process started. And so we would obviously want to give as much time as we can, but I can't guarantee for you that it would be over 24 hours.
I guess the difference between, when you talk about the adult system, those aren't emergency releases, those are just standard releases.
But they could also be matrix releases if they were an emergency. You know, it's the same dilemma. And so we would have to do more work to tell you, like, sort of in the notifications that we've done thus far, how much advance notice there's been. But, you know, some of these are quicker turn than others due to the nature of the facility.
Okay, I'm going to, before we vote on this, I'm going to strike the first portion of it because I think I have assurances that consultation occurs, and if the DA's office is notified, they obviously can advocate and share their point of view. So I don't know that we need a requirement, but I guess I remain concerned that I wouldn't want this in the adult system either, and I'd raise the same concerns if we were having emergency releases, that victims weren't given adequate notice. Because I think we can plan for it, so I'm going to, I don't know the best way to do this. Should I just move that I strike the first portion?
So the procedure that we would typically follow would be either you can withdraw your amendment and repropose it however you want, or the board can vote on it as is, and you can see what the result of that vote is, and then you could propose another amendment if that was necessary based on that vote.
Okay, I'm going to withdraw the amendment.
Okay.
And I'm going to offer an amendment that is just the second portion. If you want me to read it into the record, it's the portion that the sentence that just starts with the JDS director.
Okay,
Do you
and
need me
then
to read the whole thing?
before offering that amendment, we can do that. Are there any changes to the amendment that, as you had it originally written, that you would like to offer as part of this amendment, or do you just want it as is? Or would you like me to suggest a proposed amendment?
Thank you for giving me the opportunity. After the words forced release, or of a youth, and I would just add in Tier 3.
Okay, do we have a second? Second. Okay, we have a motion and a second. Any discussion on this new amendment? I didn't speak to the other one, so I'll just speak on this one briefly. I think that we've heard there's some issues with the 24-hour notification and the ability to do that. I think the word shall doesn't leave any room for any flexibility on that. I also feel like the underlying plan and statute already assures that DCJ, that Juvenile Services will consult with all partners on the public safety system that need to, according to statute. So I'm not going to be supportive of this amendment because I don't feel it's necessary, and I feel it's too restrictive for operations.
Yeah, I did drop the consultation, that portion of it, so.
That, I know. Okay, any other
This is
discussion?
primarily about victims notifications for Tier 3 with 24 hours.
Yes, that's what I was speaking to. Any other discussion on the amendment?
Yeah. This would be, if this 24-hour notice was not adopted, and we got to needing to go to tier three, the conversation then you mandatorily have to have with the DA's office. The DA's office tells you, yeah, this is going to take a safety plan. We've worked with this victim. What is DCJ's ability to hold off on the release in order to make sure that that safety plan can go into effect? Like, that's, I guess, my question of like, not everybody in tier three, you know, the victim may have moved to Tennessee or like whatever, who knows? But where there's a situation where there is legitimate fear on the basis of a victim and there would need to be some time, what ability is there to negotiate around that in order to get that plan?
So I think that specifically in Tier 3, there's actually a longer runway there because Tier 3 also is one of those judicial proceedings that the victim could also be notified of in and of itself. So if the victim had chosen to be notified, they would know about the Tier 3 hearing, which would then give you a runway ahead of any decision around whether or not release was happening. So that, you know, in that instance, I think you would actually have more notice than not if a victim wanted to be notified about that.
Okay, thank you.
Okay, thank you. Any other discussion? All right, Tasia, can we have a roll call vote?
Commissioner Singleton?
No.
Commissioner Brim Edwards?
Yes.
Commissioner Jones-Dixon?
No.
Commissioner Moyer?
Sorry, I need to make sure I understand this. It is now only Tier 3 that would need to be notified 24 hours before potential release. And you were saying you would already be doing that because it's a more than 24-hour process. Is that correct?
There would be the opportunity to have two notifications. Again, if the victim opted in, they could choose to be notified ahead of the Tier 3 hearing, so they would know at that point, and then they could be notified again at the point, if a release was decided upon, they would be notified again at the change of custody status. So if they were engaged at the Tier 3 hearing, that would be well in advance of 24 hours, usually.
Yes.
And Chair Baker Peterson?
No, the amendment fails. All right, so now we are back under the underlying resolution as amended. Any further discussion? All right. Oh, go ahead.
I'm going to start where I started this morning, which is I want to thank you for providing the additional information. It gave me a lot of assurances that there was a lot more specificity and engagement with victims through the process, and that there were quantitative versus subjective measures. So thank you for that. I think it's a better plan because of that, and I think people will understand it more than just a very high-level plan. Also, I do think this commission needs to come back to the topic of youth being held when that is not necessary. We know the impacts that has for youth when they miss school or they lose their job because they're in custody. So, but I think that's a different conversation than this, and I think we should have it because it shouldn't be this emergency release plan becomes the method by which we address that issue. So that's a second thing. I'm just saying. The third, I'm disappointed the commission didn't address that because I feel we're not putting victims on the same, giving them their same due as the youth who, as we discussed earlier, especially for Tier 3, are alleged to have committed some pretty serious crimes, mostly person to person. So I'm going to be interested in the data, and if the emergency releases are ever utilized, I'm going to be really looking at whether like the county did the right thing, because further traumatizing victims by not them having notification or a safety plan in place, that'll be on the county. So I'm going to be supportive of this, but I am going to be looking at the sort of daily census and like how we proceed. Again, in the past, the commission was not accountable for this. So, but now we are, and again, I'm concerned that we're going to try, and there's all kinds of mechanisms to make it happen, but we're not willing to commit to that.
All right, thank you. Any other discussion or comments?
No.
Okay. Tasha, can we have a roll call vote?
Commissioner Broome Edwards?
Yes.
Commissioner Jones Dixon?
Yes.
Commissioner Moyer?
Yes.
Commissioner Singleton?
Yes.
Chair Vega Peterson?
Yes, the resolution is adopted. As amended, is adopted.
R2, appeal of DCHS interim director's decision to adopt the Multnomah County administrative rule for the licensure and regulation of adult care homes.
May I have a motion? Second. Commissioner Jones Dixon moves, Commissioner Moyer seconds, approval of R2. Good morning. We have DCHS Director Rachel Pearl and team here to bring this forward for us. I'm going to turn it over to you.
Good morning, Chair and Commissioners. Lovely to see you all. I think it's almost afternoon, but I'm Rachel Pearl. I use she and her pronouns. I'm the Director for Department of County Human Services, and we're here today to request your approval of the amended Multnomah County Administrative Rule, or MCAR, changes for the Adult Care Home Program, or ACHP. These changes were made through the rule change process and in response to the state's decision to take back the oversight and licensing of the intellectual and developmental disability, or IDD, homes across the entire state at the end of 2025. Since this rule change was appealed, we're here before you seeking your approval of these changes. We are grateful for the providers who do this work. A few of them are in this room today, so we want to take a moment to recognize them and the care that they provide to some of the most vulnerable community members. And to our staff on the ACHP team, also some of them here today, who support these providers every day and ensure client safety and client rights are upheld in these homes. Our presentation today will include an overview of the purpose of this hearing by our County Attorney, Jonathan Strawhall, and then background on the Adult Care Home Program and the rule change provided by Stephen Esser, and I'll pass it to Jonathan.
Morning.
Good morning, Chair, Commissioners. My name is Jonathan Strawhall, Senior Assistant County Attorney. I use he, him pronouns. I'm here in my capacity as advisory attorney for the Department of County Human Services in this rule adoption process. The Multnomah County Code outlines a specific rulemaking process for the Adult Care Home Program's licensing rules, including procedures for adopting both temporary and permanent rules, as well as the required methods for disseminating and publishing these proposals. In this instance, the Adult Care Home Program published its intent to adopt permanent rules in accordance with the county code requirements, and they held a public hearing where operators were able to provide feedback on March 19th, and the department, through then interim director Pearl, adopted the rules as proposed. Under the county's rulemaking process in the code, the final required step is to seek board approval for these rules if requested by the community, which it was, and which is why we're here today. The Adult Care Home Program has worked diligently to comply with every step of this process, and as you will hear shortly, has taken great care to inform the operator community of these proposed changes and hear their feedback. The program has prepared a proposed board order here for the adoption of these rule changes, and at the conclusion of our presentation, and public testimony, we would respectfully request that the board approve the adoption of these rules as proposed. Thank you. I'll turn it over to Stephen Esser to talk more in depth about what the rule changes entail.
Thank you. Good morning.
Good morning, Chair and Commissioners. I'm Stephen Esser. I'm the Program Manager of the Adult Care Home Program, and I use he and him pronouns. Thank you for your time. Tasia, you can go to slide 2 there. It recaps what Jonathan just spoke to. The county code provides a process for the administrative rule changes. The process includes a method for the board to approve the rule change if requested, and that is why we are here today, as Jonathan stated. Next slide, please. Okay, so the Adult Care Home Program is within DCHS, and it sits under the Aging, Disability, and Veteran Services Division. We license the adult care homes within Multnomah County. We enforce the Multnomah County Administrative Rule. It's referred to as MCAR, you'll probably hear that. They govern licensing and the operation of adult care homes in the county. The program currently licenses 425 adult care homes, serving predominantly the aging and people with disabilities population, and we have a few homes serving the behavioral health population as well. A testament to the support of the rules, the regulations, the hard work of the providers out there. The consumer satisfaction rate is 95% from our last survey that was conducted. And the renewal rate for homes is 98%. So that's on our annual year-over-year inspections of homes. They may have corrections, they fix them, bring them back up into compliance, and 98% of the homes are renewed within compliance on that. Next slide, please. So a little history. Oregon became the first state granted a federal waiver for Medicaid as an alternative to skilled nursing facilities back in 1981. It was predominantly only nursing facilities and hospitals at that time existing. Assisted livings, memory cares, et cetera, were not quite up and running at that time. 1983, the county began regulating adult care homes. The county is authorized to operate a countywide licensing program, as we've stated, under an exemption to state licensure. The state requires that the county program be equal or superior to the requirements of the statutes listed there. Those are the statutes which govern adult foster homes. And just a note there, throughout the rest of the state, the term adult foster home is used. In Multnomah County, we use adult care home. 1986, an ordinance was adopted in the county code, which gave the ACHP the authority to adopt the rules and standards as necessary to protect the health, safety, and welfare of residents and care homes in the county. And these rules are the MCAR. Next slide, please. So within that exemption, there's a requirement that our program is equal to or more restrictive than, which is superior to, the requirements described within the statutes. Multnomah County's licensing program, including the program's rulemaking, is under the county code jurisdiction of Chapter 23, County Human Services. And then within the county code, it holds that standards and requirements found in the rules are necessary to protect the health, welfare, and safety of the residents of care homes and to ensure that the homes maintain a home-like atmosphere for the residents. Consistent interpretation, application, and enforcement of regulatory standards is necessary and desirable for the protection of residents of adult care homes. And then next slide, please. So the proposed rules that we put forth had to do with removal of language regulating licensing and oversight of IDD homes, which are homes that were licensed specifically for intellectual developmental disability population. The reason for the removal of this language had to do with the 2025 to 2027 Oregon legislative budget, in which ODDS centralized all licensing of intellectual developmental disability foster homes. And that included both child foster and adult foster, and that was throughout the state. And so as a result, we prior to this year have had IDD licensing within our program, and the rules were embedded within that. So we were required to remove those rules. Second to that, we clarified process and documentation standards related to care planning and protection of resident right to informed consent. And that was mainly the addition of a requirement to obtain resident signatures or residents' legal representative signatures on care plans as a means of documenting consent to receive care. And then finally, there was an update to Appendix 1 of our rules, and it's a definition appendix. And we clarified activities of daily living and brought those definitions more in alignment with the Oregon Administrative Rule definitions so that they're in further alignment with the ADLs that case management uses to help do their assessments as well. So, and the final slide is a visual timeline here of the process that we put forth. February 9th was the public notice to intent to adopt the rules. There was an open comment period and a request for hearing. And as Rachel mentioned, we held a hearing on March 19th. We heard public testimony during that time, both written, oral, and that was reviewed following. And on April 1st, the decision of the director to adopt the proposed rules was made. And then that opened a subsequent window for feedback, and a request during that time was received for this board hearing today. And here we are. Thank you.
All right, thank you very much. Appreciate that. I know we'll have some questions from the board on this, but we do have public testimony. So if you guys want to take a seat, we will bring you back up to the board after we go through that. Tasia?
I'm going to start with virtual testimony. First up, we have Ella Shepard. Let's see if I can find her. Yep. Ella, you can unmute yourself and begin. Looks like you're unmuted, but we can't hear you, Ella. We'll circle back. Ella, please try and log out and log back in again.
Hello?
Oh, there you are. We can hear you.
There. Okay, sorry, I don't know what was wrong with that. My name is Ella Shepard, and I'm a registered nurse, an adult care home operator, and representative of Advocacy for Adult Care Homes, which is a nonprofit organization representing hundreds of operators in Oregon. I'm here because these proposed rules are not simply about paperwork, and they affect vulnerable adults and providers who care for them every day. For over 3 years, operators have tried to work collaboratively with Multnomah County, including reaching out to our commissioners, and unfortunately, those efforts have failed. Operators received very little notice of this hearing. We requested that it be rescheduled. The county refused. The hearing falls immediately before the 4th of July weekend, conflicts with statewide Senate Bill 739 training affecting all care homes across Oregon, and making matters even more difficult, this hearing is taking place while licensors of Multnomah County are conducting monitoring visits in other adult care homes. If the county truly wanted meaningful participation and collaboration, they would have rescheduled this hearing. On October 6th of 2025, I emailed Program Manager Stephen Esser and his supervisors after licensors were citing operators for not having signatures on care plans. This rule did not exist, yet corrections were being cited and given. I never received a response from them. A short time later, the county adopted a temporary emergency rule, creating this very requirement. That's not collaboration, that's a cover-up. Earlier this year, I admitted a resident through Kaiser after she had spent approximately 3 years living in her car next to her condemned and uninhabitable home. When she arrived in my home, she had feces embedded into her skin. Her hair was matted with urine, dirt, and feces. She had significant cognitive impairment, no guardian, and no one legally authorized to sign documents on her behalf. But she still needed care. She needed a bath. She needed medications. She needed a safe place to live. Under these proposed rules, what should I have done? Should I have refused admission because no one could sign paperwork or a care plan? Should she have remained in her car, as my program manager had suggested? These are real-world consequences of these rules. A second operator experienced something different but equally concerning. A resident's son, who held power of attorney, after touring the home and agreeing to admission, simply refused to sign the admission paperwork, saying, "I'm not required to do anything." The operator couldn't force him to sign. The resident still required care, yet under these proposed rules, the operator is the one exposed to citations because of someone else's refusal. That's not something operators can control. The county is attempting to regulate the actions of residents and their representatives while holding operators responsible for circumstances entirely outside of our legal authority. All we do is provide care. When we are the people cleaning feces embedded into someone's skin. We are the people washing matted hair. I'm going to finish my last thought. Please do not create rules that force providers to choose between protecting a vulnerable resident and protecting our license. I respectfully ask that these proposed rules be withdrawn and that Multnomah County begins working with operators collaboratively. Thank you.
Thank you.
Next, we have in-person testimony. I'll call you up 4 at a time. First, we have Simona Berlovin, Gabriel Weaver, Anna Petrus, and Rolika Nicarici Storica.
Good morning. Whoever is ready can begin. Thank you.
Good morning, Chair and Commissioners. Thank you for the opportunity to testify regarding the appeal of adult care home program, temporary emergency rules. I'm going to address the temporary care planning. For the record, I want to state I agree with the Department of Human Services County Director's letter from December 8th.
Will you state your name for the record?
Oh, Simona Berlovan. I'm sorry. Simona Berlovan. I'm a partner in adult care home in Multnomah County and a member of the Advocacy for Adult Care Home. I apologize. My public speaking is not my forte. So I do agree with the letter for emergency rule that was dated December 8th. I do not agree with the letter, the second letter dated April 22, where more requirements were added. And I'm gonna address the care planning. My concern is straightforward. As written, this rule creates a foreseeable risk of harm by placing an administrative signature requirement ahead of a resident's immediate care needs. The rule prohibits caregivers from providing care under a revised care plan until it has been signed by both the provider and the resident's power of attorney. In practice, that signature may be delayed because the POA is out of state, hospitalized, unreachable, or simply unable to respond promptly. Residents, however, do not stop needing care while paperwork is pending. When a resident's condition changes, providers are left with 2 unacceptable choices, according to the new rules: withhold needed care while waiting for a signature, or provide the necessary care and risk being found out of compliance. Neither option serves the resident. This approach is inconsistent with the principles of person-centered care reflected in the home and community-based services framework. Care should be driven by a person's current health and safety needs, while the documentation supports that care, not delays it. The temporary rules also goes beyond the Oregon revised administrative rules. Under OAR, a care plan needs to be done within 14 days after admission, but they do not require resident or POA signatures before a care plan can be implemented. The adult care home program has acknowledged that the signature requirement was added after its interpretation of the rule was challenged. That is not in itself an emergency affecting residents' health and safety. rather than addressing the issue through the normal rulemaking process with meaningful stakeholder participation, as actually noted in the MCAR and in the Multnomah County Code. Proper rulemaking requires transparency, collaboration, and public participation. For these reasons, I respectfully ask the board to invalidate the care planning provision of the temporary rules, and then ask Multnomah County Adult Care Home Program to do the proper rulemaking.
Thank you. So if you have more that you weren't able to say, you can provide written testimony to the
Yes,
board clerk,
I will do that.
and they will make sure that.
Thank you.
Thank you. Good morning.
Good morning, Commissioners. My name is Gabriel Weaver. I'm an attorney, and I represent Advocacy for Adult Care Homes. You've already heard some of their constituents testify. I use he, him pronouns. My clients are deeply concerned about the county's proposed amendments to the rules governing documentation of informed consent for adult care homes. You heard staff refer to this as a clarification of existing rules, but it's actually a substantive and quite radical change that's inconsistent with standards of care in any other jurisdiction, certainly in Oregon and anywhere else that I'm aware of. You've heard some of my constituents testify today about why they believe the proposed rule is bad policy and how the timing of the hearing reduces public participation. I want to focus briefly on how this rule creates conflicting compliance obligations that expose my clients to unacceptable enforcement and litigation risk. My clients serve vulnerable populations, some of whom are not able to make informed consent decisions on their own behalf, and they have court-assigned representatives who aren't always immediately available. Other times, care needs change in the midst of care, and it's not possible to get immediate sign-off on changes to care plans, and this can put the life, safety, health, and well-being of the resident themselves, of other residents in the home, providers in jeopardy. And in those, as written under these new rules, my clients have conflicting obligations. They cannot simply discharge the resident. They can't refuse to provide care, but they're also prohibited from providing care until someone who may be inaccessible or unwilling to sign off on a night or a weekend is able to do that. My clients don't object to requiring documentation of informed consent, but there is no process outlined in these rules for emergent or changed circumstances that require at least temporary care or adjustments to care under emergent circumstances. And I would respectfully request that the county and its staff re-engage with my clients on the rulemaking process in order to address these concerns, in order to promote the well-being of residents and the accessibility of this program in the county. Thank you.
Thank you. Good morning.
Good morning. My name is Anna Petrus. I am the president of the Adult Care Home Provider Advocacy Association, and I'd like to point to the left side of the room. These are all amazing adult foster care home providers. Yes, most of which are from Multnomah County. We have consistently and relentlessly tried to have a direct conversation with Stephen Esser, Rachel, and everybody else that's in Multnomah County, the leaders that's supposed to be listening to our voices, which they don't. They consistently turn us away, schedule immediate urgent meetings such as today, right before a holiday weekend, where thank you so much for taking your time to be here so that the county commissioners, and thank you Chair and commissioners for actually hearing us out this morning. We want to say that I am mostly concerned about the rulemaking process. They've come to you and presented you a final rulemaking, but they have not listened to us along the way, to our emails, to our, they just keep going in at it and doing their own thing, and they're not listening to us, and then they come to you and present that they have, but they haven't. I am here today in opposition to the proposed care plan signature requirements. The proposed rule states that prior to implementation, the care plan must be signed and dated by the operator and by the resident and or legal representative. It also states that all new and updated plans must MUST, be reviewed and signed by each provider caregiver prior to providing care. I want to be very clear, we are not opposed to informed consent. Residents absolutely have the right to participate in their care and refuse services when appropriate, but this rule creates an impossible situation for providers. Every week, residents are discharged from hospitals into our homes. Many have dementia, many cannot make their own decisions. Their power of attorneys may be traveling out of the country, working, simply unreachable for several days. So my question to the county is simple. What are providers supposed to do while we wait? Do we delay medications, delay precautions, fall precautions? Do we delay assistance with bathing, toileting, transferring? Do we refuse admission? Hospitals need to clear their beds. Do we refuse them because we don't have a POA ready to sign the care plan? Or do we provide the care that our professional assessment, we have always done the assessment, tells us necessary and risk being cited because we don't yet have the required signature? There's no clear answer. As licensed providers, we already have a legal duty to assess residents, follow physicians' orders, protect resident safety, and provide appropriate care. We should never be forced to choose between complying with the paperwork requirement and caring for a vulnerable adult. A power of attorney is an important decision maker, but they are not the clinician determining whether a resident needs oxygen, transfer assistance, dementia supervision, medication management. Those decisions are based on assessment, physical orders, and professional judgment. We are not asking the county to eliminate informed consent. We are asking for a workable process. If providers have documented reasonable efforts to contact the resident or POA, the care plan should not be considered incomplete simply because someone is unavailable to sign. Regulations should protect residents' rights without delaying residents' care. Thank you.
And again, if you have more that you weren't able to say, provide it, and the written testimony will be shared with the board. Good morning.
Good morning. My name is Raluca Nikolic-Stoica. I am an adult care home provider. I'm a registered nurse, and I am the president of Oregon Care Home Council. I'm here because the rule process in Multnomah County concerns me deeply. This rulemaking record contains a factual claim that is not accurate, and the board is being asked to rely on it. In responding to public comment, ACHP justified its new care plan signature requirement by saying that the state intends to do the same thing. The statement was, and I quote, "State APD has shared that they plan to make this change as well after they have had an opportunity to implement Senate Bill 739 regulations." I want to be very clear about this claim because I was part of all the RAC meetings that happened for Senate Bill 739. There was no such discussion. As president of the Oregon Care Home Council, I participated directly in the Senate Bill 739 Rules Advisory Committee for Adult Foster Homes, and I don't have to say it. Here is the paper. I would like to introduce this as an exhibit for my testimony. I have the state-owned rule revision for that committee distributed on June 29th, and I'm submitting them. Those revisions are about oversight and licensing. The changes they changed the license duration. They added biannual relicensing with annual inspections. They moved the background check from 2 years to 3 years. And the new definitions were added, such as elopement and negligible harm. The one change that was touched is the telephone requirement, which moves from landline because they're phasing out. So that is the extent of it. What the state did not change is the care planning. The care plan definition in the state rule stays the same, and there is no requirement for resident, representative of the resident family, or caregiver anywhere in the Senate Bill 739 package. It was never proposed, it was never discussed, and it was never adopted. So the ACHP took a second-hand, unverified statement about state intent, placed it on its official rulemaking record, and used it to justify exceeding the Oregon administrative rules. That statement is not true, and the document I attached proves it. The Oregon Administrative Rule 411-051-0115 requires a completed care plan within 14 days. It does not require executed signatures, but Multnomah County does. And that justification offered that, excuse me, and that justification did not didn't happen, excuse me. For that reason, I respectfully ask the board to invalidate the care plan position that the Multnomah County is taking, and also direct the removal of any compliance corrections issued solely for missing signatures. Thank you.
Thank you.
Next, we have Petra Garau.
Yes, good morning, thank you.
Good morning, Chair and Commissioners. My name is Petra Guro, and I'm a registered nurse and the operator of an adult care home in Gresham, Oregon. I'm here to speak to Aflaw on how the rules changes are made for adult care home program. The providers who keep these vulnerable residents safe were never asked to take part. Rules that affect clinical care are being drafted behind closed doors without the clinical expertise, without regard for evidence-based practice, and no input of the people who actually deliver the care. The proposed MCARP revisions also ignore protections our state already gives to military service members. In January 2025, I was deployed to Iraq. The nation made a promise long ago that no one should be financially or professionally ruined simply for answering the call to serve. That promise is written in the Federal Service Member Civil Relief Act, which shields service members from civil and financial harm during active duty. Oregon has already put that into principle under ORS 807. A deployed reservist license would not be otherwise expire while they're serving overseas and stays valid until they come home. Oregon's own adult foster care home program furthers this. They account for a licensee's temporary absence and require a succession plan and allow for co-operators or co-applicants in this kind of situation. Multnomah County rules honor none of these, and no cooperator pathway, no deployment provision, and no accommodation for military service at all. When I was deployed, my wife had to apply for a brand new license from scratch. The county's process was slow and wasn't licensed until March 2025, long after I have already been forced to close the home in December 2024. When I returned from service end of October 2025, I had to reapply to get the license myself and didn't get it back until February 2026. The bureaucratic redundancy and cost to my family income, hardship, and disrupted stable care for our residents. The program is here proposing new compliance rules and penalties, yet it didn't ask providers for input, is not evidence-based, and still has zero provisions for military service. If Multnomah County Adult Care Home Program wants to write the rules for care, it must first work with the providers who deliver it. I also asked the county to collaborate with providers directly and to amend MCARS to match the states, recognizing co-operators, protecting deployed service members, their families, and the residents who serve. Thank you.
Yes. So thanks, everyone. So if you want to show your support, you can go like this. We normally don't do a lot. So thank you.
Thank you.
Hold on one second. Is that any more public testimony?
That's all public testimony.
Okay, great. I'll invite DCHS folks up to the board, and then we will go to commissioners' questions and comments. And Commissioner Moyer, did you have a question?
Yeah. Did we get the administrative rules in our packet?
There was a request. So there was a request to see if the commission received the copy of the administrative rules that we're adopting today.
Yes, if you look in the APR, there's a link to the rules that are changed, the line-by-line change.
Okay, thank you. All right, so we'll go to the board for questions. We've heard a lot of public testimony today. I'm sure there will be some questions about that, especially some of the circumstances that were raised and how this, the updated order will work with that. So I'll start with Commissioner Jones-Dickson.
Thank you, Chair, and I'm glad that I get to go first, seeing that a lot of the care facilities are in my district out in East Multnomah County. Thank you all for being here this afternoon. I have a ton of questions, so I guess to the board, I want to know if we can postpone the vote, because it sounds like there's some more information that we need to consider. But I'll leave it there. Thank you.
Okay, thank you. Any comment on? I'm sorry. Oh, no, I was just asking if there was, just to respond to the question about the postponing.
I think the question, that question was pointed at you. I don't know that we can determine if
sorry,
you're
what
delaying
was-
the vote.
The question was to the board, can we postpone this action?
Thank you. I think my question is there any impact if we postpone this? You know, in terms of rule adoption or compliance with state or things like that?
Currently, we're operating under a temporary rule, and I believe those run 120 days at a time. And so I can get back to you and confirm when that stop date would be. And just as long as a vote's made within that window of time, that would work. Otherwise, we, by code, can essentially replicate the temporary rule again to extend it if needed.
And you can extend the temporary rule without board action?
Correct.
Okay. All right, thank you.
Is that
Jonathan?
Yes, I think the temporary rule expires in early August, so I don't know how quickly we can get before the board again, but as long as it's before then, I don't think it has a great effect to postpone.
Thank you.
I have a couple questions before we move to that. Any, Commissioner Amoyer, do you have some questions?
I do. This is strangely an area I have a lot of expertise in. Having at one point represented adult foster homes in the Oregon legislature and also done extensive legislative work related to guardianships in that area of statute, I actually think there is a legitimate, real, impossible situation for a provider who is unable to get a hold of a guardian and has a duty of care to an individual who does not, who has been found unable to consent. I totally support that individuals who have not been put into a guardianship or similar legal situation need to sign a care plan, or if they're unable to sign, need to be documented as consenting. I 100% support that rule. I am interested in a conversation about how a provider who is struggling to contact a guardian can document their efforts related to that, because I think, again, we're trying to separate a good actor from an actor who's not acting in accordance with the values of consent. And so I'm interested in seeing if we can't add some language that specifically says, you know, yes, you try before implementation. If you cannot get a hold of them, you are, and I will say this to everybody, put it in writing, everything in writing always, or video, so that you can definitively prove your track record of trying to communicate. But I think the situation in which somebody had a hospitalization, they're coming back to your home, there is very specific guidance during that discharge, could be wound care, could be whatever. I would, if you did not follow that because you did not have a care plan, I think that that would be neglect. And I think you could be found at violating elder abuse laws. So I think there's a medium, I think there's a solution. I don't think we throw this out, but I do think we need to understand that, you know, guardians don't always live in the state. Guardians can be hard to get a hold of. Sometimes guardians are not doing their job. And in those cases, Adult Protective Services is well aware, and I recommend every single provider, if you cannot reasonably get a hold of a guardian, there needs to be a call to Adult Protective Services, because that is a guardian not doing their responsibility, and that does endanger long-term. The military issue, I'm not as familiar with. I'm sure we don't mean, one person qualifying for a license is not the same as somebody else qualifying for a license, and so I see why this state did a dual approach if one might be called into active duty. So I'd be interested in that conversation, but I don't think we're there on these rules. And I think we need to figure out how we write rules for a situation that I think could very likely happen, which is, you know, a hospitalization, even an ER visit with follow-up care, and an inability to get a hold of a guardian needs some kind of documentation of effort. But I think we cannot put a provider in a situation where they are choosing between compliance with this rule and compliance with elder abuse law.
Can I respond, Commissioner Moore? I just want to be clear that this rule currently provides for informed consent before services can be provided. So the rules already provide for this informed consent, the consent of the resident or their representative before services are provided. So that's already a requirement, which would be difficult in many instances, such as the instances that Ms. Shepard brought up during her testimony. There is an exception process that's built in that's in rule that folks can seek an exception for any rule with very limited exceptions. But I think in this instance, if there was someone that needed care straight away, and they would seek an exception under the current rule, so that informed consent would be a problem for that person without adding a signature or not. It really,
what are your hours of, I'm just going to be real, because I know that these administrative rules, and I think sometimes they don't live in reality. And I mean that from a state perspective, not from the county, but like, do we operate 24/7, 7 days a week? Yes. No, not you. Yes, you do. Does the county, like if I needed to seek such an exception, would that be available 24/7, 7 days a week for an immediate response?
Yeah, I understand, Commissioner, but the current rules couldn't be complied with in the exact same instance.
Yes, and they're not. I mean,
so adding the signature seems to be what people are raising an objection to, but the informed consent itself is already required. So I don't.
I hear you. That was not my question.
Okay.
Okay, so thank you. If we can keep the comments to the minimum so we can proceed. Thank you.
My question is, you're saying current rules say you have to do this, you need to seek an exception. I mean, my grandmother spent 18 years in an adult foster home here in Oregon. She happened to be a frequent person who experienced UTI. So that can be an ER trip at 1 in the morning. You know, my mother was incredibly active, but did she ever travel? Sure. I'm going to tell you, in reality, that the administrative rules set by the state is not followable, and it jeopardizes every provider. That's just reality. And you're saying, well, it's already the rule, but it's not. If we are not open 24/7 with a person who can make that decision 7 days a week, then that is a rule that's not followable. So my question is, are we available 24/7, 7 days a week?
We do have the ADRC, which can be contacted, and then we share managerial on-call, so we actually do
Can ADRC approve this?
No, they would contact whoever, either myself or the 2 other supervisors for our program that are on call. And so we do get calls, you know, sometimes there's a disputed, like you said, the UTI example, a resident goes to the hospital. We do get calls after hours and on weekends when there's a dispute as to whether it's okay for a resident to return to the home based on change of care levels. So that is a service that our county ACHP provides.
Yeah. That makes me a little wildly uncomfortable that you would be approving you don't have a relationship with the client. Like if I were in Medicaid, I would call the case manager, and even though they are not legally the guardian, they do this troubleshooting and they are going to make sure, okay, I know what's going on. You are a licensor. Like, why would I call, no offense, but like, you are not an appropriate entity to decide the care of an individual over, I mean.
I thought I was answering your question as to was someone available.
Yeah. No, okay, I get that.
To do an exception. That's all.
Okay, no, I appreciate that.
And usually what we're involved in is the assessment that the operator provider has made. They reassess the resident and they say this fits within the classification level of the home or it exceeds the classification level of the home. And then that's the licensing decision that we either support it or have that conversation. So, yeah.
But do you, under Oregon administrative rule, have the authority to consent to a treatment plan for someone? Because that's what this is about. Can you consent for treatment?
The resident themselves is the consenting entity.
Yes, that's my point, but they have a guardian who can't be reached, so I'm asking if I'm calling.
So in this instance where you're saying that the resident needs the consent, they're at the hospital, so if that consent is unclear, would they not stay at the hospital until consent could be clarified?
Hospital's not going to keep you.
Okay, then right, under that we would say we'll permit an exception that we know your best intent is to get consent.
But you didn't put that in the rule. Okay, I guess we're just going to agree to disagree.
No, I mean, sorry. I do also just want to say that when we published the intent for rule February 9th, there was an open period of time for comment, written comment. Then that whole period came and went, and this was not expressed during that time. So it is a valid point to be looking at further, and I'm glad we're having this conversation. And then when we actually came here on March 19th and hosted the hearing, that was not brought up during that time either. And so up until we're finally here today, this specific issue about the timeliness of consent was never actually even brought forward for consideration in this rule. So I'm glad it is coming up, and I'm glad we're having this conversation, but I just wanted to be clear about that. It wasn't something that we had heard and tried to get around or anything.
No, I hear you. I've also, again, I have represented adult foster home workers, home care workers, and I will tell you, the administrative rule process is not one that is easy to track, follow, and engage in. That is universal and is not a reflection of this department specifically. That is just, it's very difficult. I support postponing this.
Thank you, Commissioner Moyer. Commissioner Singleton, any questions at this point?
Thank you, Chair. I think, and I appreciate Commissioner Moyer, your questioning as well. I am also in support of postponing this. I would encourage you all to look at if you can pull this one that is around informed consent that needs more work. And really look at doing more intentional engagement with our partners. I think regardless of the process we attempted to use, clearly we missed some conversations that I think we just need to say, I'm sorry, we missed this. We're going to come back and do this a different way. And particularly, I don't want to be under a timeline because of a temporary rule. So I would appreciate knowing how we can kind of bifurcate this and deal with the one about removal of language, regulating licensing and oversight, since that's now at the state. That seems easy. Potentially the third around definitions, but this second one that you're bringing today feels like they might need a different trajectory. So my question is, can these be taken apart so that this one that needs more intentional engagement and partnership can get the time it needs to actually do that work?
Thank you, and Commissioner Singleton, I appreciate that. That's exactly where my line of thought was going to. I also know that we're adopting these by emergency because of the changes at the state level, and I understand that there's a process that it will be happening for kind of normal course of action rule adoption. And is there a way to have this the change that's under debate right now a part of that process? at a longer timeline.
Yeah, I think we'll confer, look at it, and then figure out what the best operational plan to do this is. I agree that it feels there's been no comment about the removal of IDD language. That seems pretty straightforward and on the nose. Definitions aren't making a tremendous impact. They're just clarifying. So that does seem to make sense. But I'll confer with Jonathan afterwards, and we'll follow back up, and then can go forward. It was also mentioned there is Senate Bill 739 went into law. That is down the road for us, so there is going to be another rule change coming, and so it could very well work that we incorporate this aspect into the next iteration or something, but we'll follow back up.
Okay, great. It looks like we have time on August 13th to bring back what may be, the parts that are ready to move forward. So we do have time in August to bring this back if folks are inclined. Did you have any?
I just wanted to thank our ACHP team and our providers. I think that when I'm hearing folks say that that wasn't the primary objection, it wasn't. That doesn't mean to say that you all didn't feel that way. But the primary objection was to the rule changing process. And so I do think clarification around what exactly the concerns are. And the intent, I know I also heard it inferred that there was not great intent in bringing this to a formal rule because it was in the program expectations, but in fact that was meant to align and ensure that rules are consistent across the board. Hearing that there's more concerns about that, I want to continue to uplift that I think there's good intent on both sides, and we can have great partnerships and not always agree, and there's opportunity to have those conversations. And I think I know that we look forward to doing that, but I just want to clarify some of those things because they were stated on the record that and I think it's important for us to talk about what the intent was. Impact might be different, recognize that, but we can navigate that path moving forward and hopefully have a better outcome.
Okay, thank you. So I would entertain a motion to.
I'm sorry, Chair, I just had one other.
Oh, I'm sorry, Commissioner Singleton.
So for the department, I would like to see a more detailed engagement plan with our partners to actually understand how they'll be engaged so we know that that's really happening and has the impact that we want it to. I appreciate the impact versus intent, but where we're at today is not where we want to be, and I know that that's true for the department, so I want to see that before you're coming back with that second piece around informed consent.
Yes, thank you, Commissioner. And so my expectation is that's what being brought back in August will be the pieces that are around the state updates and not necessarily the specific rule change that obviously needs more conversation. So I would entertain a motion to postpone item R2 until August 13th meeting. Second. All right, Commissioner Jones-Dixon moves. Commissioner Moyer seconds. Approval for the motion to postpone. Tasia, can we have a roll call vote? Actually, all those in favor, please say aye. 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 Okay. All right. The motion is approved. Thank you, everyone, for being here today. We really appreciate your voices as a part of this process. And we will, go ahead and move on to R3.
R3, Notice of Intent for DCS Transportation to apply for the Oregon Department of Transportation Carbon Reduction Program grant.
May I have a motion? Second. Did you move? I'm sorry, I didn't hear that. Commissioner Jones-Dixon moved, Commissioner Moyer seconds. Approval of R3. So for R3, we have a grant opportunity before us. We know that burning fossil fuels drives climate change. We're actually right at around the 5th anniversary of the Deadly Heat Dome event from 2021. And we have places right now like Europe and the East Coast of the United States who are experiencing their own unprecedented heat events. I'm really reminded of the deadly consequences we face if we don't take action. That's why I'm really appreciative of this work that's being brought forward and that Multnomah County continues to be a leader in promoting energy efficiency, conservation, and climate actions. With that, I will turn it over to the team who is here to talk about this from our DCS department. Good morning.
Good morning, Chair Vega Peterson and Board Commissioners. My name is Lance Calvert. I am with DCS Transportation, Engineering Services Manager and Interim County Engineer for the county. Before you today is a request for notice of intent for this grant, as was mentioned and is outlined in the packet. This is a Federal Carbon Reduction Program grant that is run through the Oregon Department of Transportation. This is a grant that's specifically targeting rural parts of the state and areas in Multnomah County that would apply to this grant would be areas outside the metro boundary, outside the UGB. And so we have located and worked on developing a couple of potential sites that work for this grant opportunity in both the far east and far west sides of the county, specifically to deploy and purchase and install 2 solar-powered electrical vehicle charging stations that could service the rural parts of the county. These are essentially manufactured for scalability and deployment and low total cost of ownership. They have off-grid capabilities and are fairly able to be mobile and used in emergencies. I think they are a great fit for our transportation fleet and those rural facilities in the county. They work well with and align with the county's climate action plans and meet the requirements of the state and federal grant funding opportunity. One thing I would mention is that we did get word last week that from ODOT that they would like to see us increase the total request in the packet is $200,000. They had requested we increase that to $250,000 for contingency funds. So that's the only clarification in the packet that I wanted to bring to your attention, and happy to answer any questions about this NOI.
Thank you so much. Do we have any public testimony on this item, Tasia?
No, Madam Chair.
Okay. I'm going to open it up to the board for any questions. Commissioner Moyer.
No questions.
Commissioner Singleton.
No questions, just thank you and appreciate the state offering more money in something, so we'll take it.
Thank you. Commissioner Brim Edwards. Commissioner Jones-Dixon.
No questions, thank you.
Okay, I don't have any questions either. I hope we get this grant. It's something we can do a lot of good with it. So thank you so much. Tasia, can we have a roll call vote?
Commissioner Jones-Dixon?
Yes.
Commissioner Moyer?
Yes.
Commissioner Singleton?
Yes.
Commissioner Brim Edwards?
Yes.
Chair Vega Peterson?
Yes, the notice of intent is approved. Thank you.
R4, resolution to adopt Safer Sandy Boulevard concept design.
All right. May I have a motion?
So moved.
Okay, Commissioner Jones-Dixon moves, Commissioner Brim Edwards seconds, approval of R4. All right, we have an update today on the Safer Sandy Boulevard design. Turn it back over to you guys. Thank you again for being here.
Thank you again. I, again, am Lance Calvert, the interim county engineer and engineering services manager for DCS Transportation. Irini Farrell is with me today, the transportation project manager on this project, and she will go through details of the Safer Sandy design plan and planning project that we went through. One thing I failed to mention on the last item is I did want to do a shout out to DCA Facilities and Fleet and our Office of Sustainability for helping put that together in a very, very short time and frame. So with that, I will turn it over to Irini to step through the presentation that we have today on the Safer Sandy plan.
Thanks, Lance. Hello, everyone. My name is Irini Farrell. Thank you, Chair Vega Peterson and Board Commissioners, to have me again. I'm here to present another corridor plan. This is about Safer Sandy, and our team in transportation calls this my baby, Sandy, because this has been another part of the county transportation network that has been really dear and close to our team. So next slide, please. So Safer Sandy is a little different than the Main Streets and Halsey project that I presented to you a few months ago. This project really aims to bring Sandy to current standards to make it more bike-friendly, walking, driving, and access to transit. It will address some of the safety infrastructure gap in this very diverse corridor. So this is a planning effort to take a look at Sandy and how we can bring it back to where we need it to be. So next slide.
We have some commissioners with hard stops coming up, so if you don't mind going a little bit quicker
I'll
than
go
you would.
super fast.
Thank you.
So 201st and 230th, that's a part of Sandy that is within Multnomah County jurisdiction, but it's also, there's a little sliver of City of Gresham part. So we worked with City of Gresham, City of Fairview, and TriMet, and ourselves as like the key project members for this effort. We're looking to make Sandy and fill it in with the necessary bus stops and sidewalks and also bike lanes. Next slide, please. So I've taken a lot of pictures of Sandy, but this is the one that I always end up showing because it's the Google view, and you can see there's a woman in front of Quail Hollow who's just sitting on the edge of the road, and it kind of shows how bad or how deficient the road is to support our local needs. So the bus stop is right on the edge of the road. There's not a lot of lighting, there's no sidewalks, and there's no bike lanes. So next slide. This is a slide to talk about the diverse kind of communities. There's a lot of mobile home parks as well as apartment complexes, but also there's a big community in Sandy. The other thing to mention is that there's been a big change and growth in truck movement because the Amazon facility came about 4 years ago in North Fairview, and also a lot of industrial needs in Sandy. So there is a bigger growth of need for safety improvements because of the changing landscapes on Sandy with the conflict of truck movements, higher traffic, and also the need for people who are coming in into the city of Fairview. So next slide, please. So the great thing about this project is it's not only just a planning project, this is just the first phase of us bringing Sandy to the standards that we would like. So the corridor planning effort started in fall 2024, and then we had wrapped it up into where I am here with you today. The next phase of this project is to bring into more detailed engineering design to 30, 60, and 90%, and then bringing that money over to actually construct some of the safety improvements in summer of 2028 to 2029. We are pushing to get some more additional funding so we can stretch that construction from 201st to all the way to 23rd and see what we can do with that. And then the future remains for us to finish from 223rd to the 230th portion of the planning study. So next slide, please. So this is just a planning timeline to show you the efforts that we've done in the last year and a half of this project. The first phase, we really try to make it into a community-centered focus and understanding where people feel unsafe in Sandy. We also take a look at the existing plans that's already been done. There's been decades of work trying to bring Sandy to where we want it to be. And also, our road team actually went on a site visit to really experience what it's like to walk across. So we did kind of like a road audit to understand with a local resident, to understand where they would feel the need for those improvements. So, and we also did interviews with different groups of people, including the Truck Association, to understand what their needs look like. And at the same time, we also asked Fairview Elementary to give us an interview. So different groups of needs throughout the first phase. And then we followed up into the second phase where we come up with we took what we heard from people and best practices and the existing condition of Sandy. And we have a design criteria to decide what that could look like, including the draft cross-section. So we brought it back to the people that we spoke to. And then we also brought it to our internal team to talk about what are the benefits of that. So after that, I'm talking really fast, so let me know if, but I'm trying to get it as soon as possible. But now we're here in the draft corridor design where people did pick an option that would be best for Sandy. And next phase, please, next slide. So this is a summary of the public engagement. We did do 3 rounds of engagement for each phase, and we went to different community events that happened throughout the year. There were 9,000 mailers sent. This was intentional for us to make it so it's really half a mile of the radius rather than just everyone in Fairview or everyone in the greater area, because we really wanted to know how people felt about using that road intentionally. So it does look a little less than what we would bring out for a project like Burnside. So this is a very community-centered design that we tried to get. But we did get a lot of engagement. About 500 residents subscribed to the project and wanted to be in the loop for the next phases. Next slide. This is just pictures that we took. We went to the Quail Hollow Valentine's Day event to talk to the residents over there. Some summaries in Spanish, and also when we went to the pantry about the notes that we heard from people. Next slide. Okay, another example of our engagement effort. Next slide. This is just an example of what we did in the existing conditions and what we pointed out as deficient and what data we collected during that initial existing conditions. Next slide. These are the main meat of the project. So we had come to the public with option A or B. One is multi-use path where they share a bike lane and a sidewalk with one sidewalk, or a bike lane and sidewalk and a bike lane on the sidewalk on either side. The public came to us and there was a close call, but option A is the one that we have decided and they have decided they wanted to go with. Next slide, please. So this is just a result to show which option was chosen by the public. About 45% really cared. And then when we asked who and what the demographic who responded to the survey, a lot of people did overwhelmingly say that they live there or frequently visit Sandy. Next slide. So this is just another example of what we came up with to kind of show our improvements. Next slide. And another example, next slide. So next phase, my favorite part, because this time I actually have an answer for you. We are moving into engineering with about $6.5 million for design and construction. And we did get a fiscal allocation from Congresswoman Maxine Dexter of about $850,000 to continue this project and stretch it as far as we can. And with that, next slide, I think we're done. I want to give a thank you to the City of Fairview, who's really been a partner with us on this, specifically Sarah Selden. She has been my partner throughout this project, and all the guidance in the transportation management and the transportation team who's been collaboratively working on this project with me.
That's great. It's great to hear about the partnerships and to see the level of community engagement that went into this. Well, I'm going to call on commissioners to see who has any questions or comments. Commissioner Singleton.
Excuse me, no questions for you all. Thank you for the great overview and for the engagement that happened on this project. Looking forward to seeing construction, and I love that we have money identified, so nice work.
Great. Thank you. Commissioner Brim Edwards.
No questions. Thanks for the presentation.
Thank you. Commissioner Jones-Dixon.
No questions, just comments. Thank you for just your leadership, and ditto to everything that Commissioner Singleton has shared already, and the chair.
Thank you. Commissioner Moore.
How many ADA ramps are going to be on this project?
That is a Lance question.
There are several. So each intersection will include multiple ADA improvements. I think one of the interesting things about this project is the separated bike facilities that will parallel the sidewalk, much safer movement for bikes and pedestrians. So I'm really looking forward to that project. Specific numbers I don't have at the tip of my tongue, but
coming to say
56.
Oh, Jessica's on it, 56. So, but several, yes.
Thank you.
Great.
That's a lot.
Yeah, we don't want to undersell the impact of this. Yeah. No, thanks again. Again, level of community engagement. It's a really comprehensive plan. Everything from building sidewalks and the ramps, crossings, the protected bike lanes is great to see, and the lighting and tree improvements are all adding to really the placemaking of the neighborhood. I do want to thank the transportation team for the work on this, the partners at City of Fairview and Gresham, and of course, thank you, Congresswoman Dexter, for her partnership and support of this project. It is going to make a big difference into the community. Tasia, can we have a roll call vote?
Commissioner Moyer?
Yes.
Commissioner Singleton?
Yes.
Commissioner Brim Edwards?
Yes.
Commissioner Jones-Dixon?
Yes.
Chair Vig Peterson.
Yes, the resolution is adopted.
R5, authorizing settlement of lawsuit, Estate of Richard Forrest v. Multnomah County et al., United States District Court Case Number 320-CV-01689-SI.
May I have a motion?
Second.
Commissioner Jones Dixon moves, Commissioner Moyer seconds. Approval of R5. We have Andy Jones from the Deputy County Attorney to present this to us. Good morning, or good afternoon.
I always forget that. Good afternoon, Madam Chair, Commissioners. Again, Andy Jones, Deputy County Attorney. I am here seeking authorization from the board in public session for settlement of a lawsuit accompanied with a release of all claims involving an in-custody death back in July of 2019. I've had the opportunity to speak to all of you individually. I'm here seeking a vote to authorize as part of that settlement payment of $891,012.25 out of the risk fund. Assuming that's approved by the probate court, that would resolve the lawsuit and all claims.
Thank you. Did we have any public testimony on this item?
No, Madam Chair.
Okay, do we have any questions from the board on this item? Okay, Tasia, can we have a roll call vote?
Commissioner Singleton?
Yes.
Commissioner Brim Edwards?
Yes.
Commissioner Jones Dixon? Yes. Commissioner Moyer?
Yes.
Chair Vig Peterson.
Yes, the settlement is approved. Thank you, Andy.
Thank you for your time.
All right, we're a little bit over. I know some folks have to leave. Is there any board comments for this week?
I have some board comments.
Okay, Commissioner.
Yeah. So I just wanted to notice that Commissioner Moyer and I will be bringing forward an APR for another work session on the request for the county investment in the MODA arena, especially given the fact that currently we have scheduled a potential discussion of a resolution on the MODA Center on later in July. And the commission really hasn't, to date, we've had a very minimal discussion about the MODA Center and the cost to the county. You know, as I'm just going to speak for myself here, not Commissioner Moyer, she can add in, but you know, why do I feel strongly that we need to have another work session? Obviously, our previous work session, the Blazers were a no-show, and we also received very little detail on the construction plans and the costs, something that at least I've been asking for 5 or 6 months, and I know as have many others as well. The economic impact report that was provided to justify the, you know, almost $600 million investment, with the county portion being over $100 million, was, you know, grossly out of date, provided scant data to support their jobs and economic impact numbers. So as I stated at the meeting, we need to see the details of that, again, to right-size the investment we're being asked to make. In addition, at the last meeting, it appears the county's receipt of a portion of the transaction tax has changed since original discussions, further reducing the funds that county would receive. It also, there's a higher dollar amount for the bonds that has not been discussed in a public meeting. In addition, the county requirements that we shared with the city and others and the state, frankly, months ago regarding labor harmony for the operations and maintenance work, a project labor agreement, a community benefit agreement, a limitation on new tax increment financing districts, which further reduce county property tax revenues, all have not been addressed. There's other just very fundamental language like the clawback. How do we ensure that there's alignment between the bonds, the county's commitment, and the Blazers actually staying? So lots of questions that actually, and yes, negotiations often happen in a different environment, but the commission really hasn't had a substantive discussion about our requirements and our approach, or even the actual level of investment. And so we'll be bringing forward an APR to have that discussion. And obviously want to work in a way in which we can effectuate the Blazers coming and having a discussion with us, given the just size of the investment and the partnership they're asking of the state and the city and the county. So that's all I've got. And I don't know, Commissioner Moore, if you want to add to that.
Yeah, I completely agree, believe that there are more conversations to be had. I also would like the commission to discuss what information we have to have before we move forward on anything, because I feel very uncomfortable about being pushed on a timeline where the other partners are not providing the necessary information for us to be really voting on anything. And I do understand it is only one of many votes, but I am wildly uncomfortable with the degree of information that we have been provided or the amount of input the commission has had thus far in conversations about what we are or are not willing to do and under what circumstances.
Great, thank you. And I really look forward to that APR. When we had the conversation last week, we had, dates for the upcoming actions, and all of those were tentative because it really does depend on the conversation that we want to have at the board. I agree. There's a lot of very basic information that we have not received, including the plans and the details of the plans for renovations that I have made a request of the mayor to have those delivered to us. So really look forward to that. And as I said last week, this is really just that work session was the beginning of our conversation, and welcome further opportunities for that. So thank you both for bringing that forward. We look forward to working on the timing of that. Commissioner Singleton, any updates?
Thank you, Chair. I will just add my agreement that further discussion needs to happen. And I would say the email response we got that included some information from the city and from Donnie did not contain all of what I heard in our conversation at the first work session. So I would love to make sure that the city is reflecting more accurately what we've talked about and asked for as a board in regards to the Moda Center deal. And I would just further say, I think that we should be looking at taking our vote after the city of Portland takes their vote, so we understand what resources they'll be putting into this deal. But that was not my planned comment. So thank you, commissioners, for bringing that forward. I look forward to having a more concrete conversation. I just wanted to flag, because the application deadline is tomorrow, that the Oregon Translation Advisory Council is seeking volunteers who are fluent in Chinese, Arabic, Lumane, Korean, Nepali, Japanese, or Somali. And you can access that application at oregon.gov/languages. I can save the rest of mine other than to say happy 4th to those in the room and out in the community. Thank you.
Commissioner Moore, did you have any other? Okay. Yeah, I just want to add well wishes for a safe and happy Independence Day weekend. And we know a lot of people are going to be outside on our waterways, and just want everybody to be safe and careful as they celebrate with friends, families, and loved ones. Thank you, everyone. That concludes today's regular board meeting. Our next meeting is Tuesday, July 7th at 10 a.m. And our regular meeting on July 9th has been canceled. There being no further business, we are adjourned.